Hi, everybody. This is Rob Hudson. We'll get started here in just about 3 more minutes to make sure everybody has a chance to get signed in and participate. So maybe about 3 after the hour. Good morning, everybody. My name is Rob Hudson. I work at FERC with the Office of Enforcement in the Division of Audits and Accounting on the EQR branch with all of my colleagues who are going to be speaking today. I'm going to hand this over to Kristen Fleet, who's the Acting Director of the Division of Audits and Accounting, for her to get us started.
Kristen, we're having some trouble hearing you. I'm not sure if you are connected.
Thanks, Marina. I think I was having some technical problems. Can you hear me now?
Yep, loud and clear.
Okay, did you want me to go ahead and get started, or is Rob going to start?
You can go ahead. Thank you.
Okay, thank you, Marina. Good morning and welcome to the EQR Reassessment Technical Conference. I'm Kristen Fleet and I'm the Deputy Director of the Division of Audits and Accounting. I'm also currently serving as the Acting Director and Acting Chief Accountant of the Division of Audits and Accounting. I want to begin by thanking Jeff Sanders and his team for all of the work they've put into the EQR reassessment project. Not only have Jeff and his team planned this tech conference, they've also spent a significant amount of time reviewing all of the current EQR data fields and thinking about improvements that can be made. There have been few changes to the EQR data fields since the EQR system was implemented in the early 2000s, and a number of years have passed since the last significant update. We believe the time is right to modernize the collection and really think about whether we are collecting the most useful information. I want to encourage everyone to participate in today's meeting. We want the EQR system to be useful to everyone, including EQR filers, EQR data users, and FERC staff. The best way to reach that goal is to have an open conversation about your feedback and concerns. Thank you. I will now turn the meeting over to Jeff Sanders.
Good morning. Thank you, Kristen. Good morning. Welcome to today's meeting. Thanks to everyone for joining our virtual EQR Tech Conference. I hope everyone's doing well and staying healthy. I'm Jeff Sanders, the branch chief of the EQR group in the Division of Audits and Accounting. Our branch handles the Commission's EQR program. And as Kristen said, a number of FERC staff on the meeting today have put a significant amount of time helping to prepare for this meeting, and many are the same people who put significant amount of work into the EQR program throughout the year. We'll introduce ourselves as we speak throughout the tech conference today. At the EQR user group meeting this past September, we discussed that the EQR reassessment consists of two parts. The first is a collection method, and the second is an assessment of the data fields. We intend to have multiple tech conferences to cover the data fields, and the purpose of today's tech conference is to begin this conversation with the industry and the public, and to begin to get feedback on proposed changes and modernizations to the EQR program. So we envision multiple tech conferences over the next few months, and we're looking forward to hearing from you during these meetings and getting your feedback on our proposals. You can find the meeting agenda and slides in two places: on the EQR page of FERC.gov under the heading EQR meetings, and under today's date on the FERC event calendar. There's a link here to the event webpage. These materials will also be available after the meeting. So with that, I'll hand it back to Rob and we'll begin. Thank you.
Thanks, Jeff. Marina, thank you. Perfect. So just to go over some quick logistics, as you've noticed, all callers are muted upon joining the conference, and only the moderator or host will be able to unmute people. We encourage, as Jeff and Kristen have said, everyone to participate in the discussions. Just click the hand icon to raise your hand and wait to be unmuted to speak. I will notice your hand being raised when you raise it. But when you're done speaking, if you can, we're fairly sure the hand icon remains raised, which is strange, and I can't turn it off for you. So if you can remember to lower your hand by just clicking the hand icon again. We have the chat box enabled. It's turned on to encourage discussion on all the topics that we're having here, but staff will not be monitoring the chat, so please be respectful. The Q&A text box is enabled. We are monitoring it. So if you have specific questions or concerns, please put them into the Q&A and we'll review them and answer as we can. This conference is being recorded. You should have gotten a little pop-up message in WebEx about that. It'll be made available on the FERC website as soon as it goes through the proper IT conversions and all that stuff. Also, in the past, for some of our user groups, we were doing some live questions up through the EQR mailbox. Just because we want everybody to be engaged in this discussion, we won't be live monitoring the EQR mailbox. However, as anytime, you can always email the EQR inbox at eqr@ferc.gov, and we'll review them after today's conference. So if there's more information you have on a particular subject today that you wanted to get to us that we discussed, please make sure to get it to us at eqr@ferc.gov. And with that, I'm going to turn it over to Marina to start with our presentation. Thanks so much.
Good morning, everyone. My name is Marina Fishbein, and welcome to our first technical conference on the reassessment of EQR data fields. We've chosen about 24 fields to focus on today, and we plan to present them in groups based on how the fields are interrelated or how they impact each other. The format for today's tech conference will start with staff sharing our presentation for each field or group of fields, and then we'll have time for discussion after each section. Feel free to ask questions at that point, just for clarification if something wasn't clear. We can kind of go back and cover anything that you'd like to see again. We want to make clear that staff's proposals today are just that, they're proposals. These are not locked in stone, but are rather staff's proposed options for changing each field. For each set of fields, we will present our proposed changes, and we hope that participants can then help provide a robust discussion on these fields from their perspective as EQR filers, preparers, and data users. When we open up the floor for discussion, we want to encourage participation and for everyone to share their opinions and thoughts on our proposals, or feel free to add their own. Let's go over what we'll cover today. I'll give a project overview followed by a presentation on identification data fields and on location and balancing authority fields. We'll take a 15-minute break and resume with a presentation and a discussion on date fields. And then we'll take a lunch break, which is going to be about an hour long. And we'll return after lunch to cover product name, category other, and Appendix A. And we'll also discuss bundled, grandfathered, bundled, and requirement service. We'll have a 10-minute break, then have a discussion on product name, specifically renewable energy certificates and ramping as part of the category other in Appendix A. We'll take our final 10-minute break after that and close with a discussion on any additional products you'd like to add to Appendix A, and then we'll wrap up for the day with closing remarks. The fields that we don't cover today will be discussed at a future tech conference, so we ask that discussions please stay on topic for what is covered today. The EQR data collection method was the focus of our last users group meeting, which was held in September of 2020. However, during today's technical conference, we'll be focusing on the EQR data fields assessment, not on the method of collection. Before we begin discussing staff's thoughts on field enhancements, we should first take a step back and refresh everyone's memory on XBRL CSV, because many of our proposed changes to the data field depend on adopting a new data collection method. XBRL is an open source international standard for digital reporting, which increases accessibility of information. Many of you are probably aware of XBRL, which was recently adopted as the required filing format for several forms at FERC. XBRL CSV combines the efficiency and simplicity of the CSV format with the XBRL benefits of standard structured data. XBRL CSV is currently staff's proposed data collection method. The following field enhancements and changes to the fields themselves are based on the assumption that we'll be using XBRL CSV as our data collection method. The enhancements we'll discuss today wouldn't be possible unless we dramatically reconfigured the current design of our 3 filing systems. We'll proceed with our discussion today under the assumption that the current system will be replaced with something more flexible. And as staff mentioned at the last users group meeting in September, staff is considering the XBRL CSV format. Staff proposes that most of the fields in the identification section of the EQR can be populated with data from other FERC systems, including company registration and e-registration. So filers wouldn't need to enter them manually into their EQR submission. The system would be able to retrieve that information based on the CID, which is field number 3, and it's a unique number that identifies each company, and each filer must have one to submit an EQR. The fields that would no longer be manually entered are shown on this slide. They include company name, contact name, title, address, city, state, zip code, and country, and also the contact phone and email. This slide breaks down staff's proposed modifications to the points of receipt and delivery by contract and by transaction. In the top section under contracts, we propose modifications to the 2 balancing authority and the 2 location fields. We propose to shift the data collection focus for these 4 fields in the contract section to be transmission product based, as opposed to all products that are covered within a contract. Also, a minor change shown in the middle column is to add the A in red text for the word area, for example, as in the point of receipt balancing authority area. For the transaction section shown on the lower half of the slide, the reporting requirements would be unchanged for the point of delivery balancing authority area and for the point of delivery specific location. In the next slides, I'll go over these proposed changes in greater detail. We propose several modifications to the point of receipt of balancing authority area, which is field 39. On the left side of the slide is the current definition for this field, which is I'm just going to read it out loud. So the registered balancing authority, formerly called NERC control area, where service begins for transmission or transmission related jurisdictional sale. The balancing authority will be identified with the abbreviation used in OASIS applications. If receipt occurs at a trading hub, the term hub should be used. So what we propose to change is the first sentence in the definition to insert the text in bold on the right side of the slide. The first sentence of the new definition would say, the registered balancing authority area where jurisdictional transmission or transmission related product is received if designated in the contract. We propose to remove the section in the parentheses that refers to the NERC control area. And we propose to keep the rest of the definition as is. A contract may have multiple transmission related products sold under it, and the data that we collect in this field would be more robust if analysis could be done at the product level. Filers who submit the EQR would need to continue to interpret a given contract to determine which transmission related products are covered by that contract. Staff proposes to modify the current definition slightly for the point of delivery balancing authority area, which is field number 41. And I'll refer to this field as PODBA. The left side of the slide shows the current definition for PODBA, and the word sale is in bold. We propose to modify it to product, as shown on the right side, also in bold. The modification of the definition of PODBA follows the same approach as for the point of receipt balancing authority area, which I just discussed in the previous slide. We propose to shift the reporting for PODBA to be product-based. And as stated earlier for PORBA, filers who submit the EQR would need to continue to interpret a given contract, determine if it is transmission related, and if this field is specified in the contract, then they'd report the point of delivery balancing authority area. This slide reflects our proposal to modify the point of receipt specific location, which is field 40 in the contract section. I'm going to use the acronym PORSL and PODSL going forward for simplicity. So PODSL is the point of delivery specific location. That's on the next slide. They're both free-form text fields, which means filers are able to put whatever they want in these fields, and they have been. One of the most common answers we see is the word multiple, which doesn't convey anything specific or useful for data analysis. Another thing we're seeing is that filers aren't making a distinction between PORBA and PORSL or PODBA and PODSL. So they're interpreting the requirements for these fields to be the same, and they're not meant to be. Therefore, we propose to remove the reporting obligation for PORSL for most filers, except for jurisdictional transmission or transmission-related products, if the field content is specified in the contract. The proposed change to the definition is shown in bold on this slide. This slide reflects the same concept that I just covered on the previous slide. We propose to modify PODSL, the point of delivery specific location, field 42, only in the contract section. We're not proposing to modify the definition of PODSL as field 58 in the transaction section. We propose to remove the reporting obligation for PODSL for most filers except for jurisdictional transmission or transmission related products if the field content is specified in the contract. The proposed change to the definition is shown in bold. We look forward to hearing from you during the discussion how this change would affect your analyses or submissions. Hopefully, it'll be a reduction of burden for most filers. So here we've reached our first discussion portion of today's tech conference. If you have questions, now is a good time to bring those up. And while you think about those and click the raise hand button, I'm just going to go through this list of discussion points for the moment. So for the contract section, we'd like to hear your thoughts. Specifically on our proposed changes to PORBA, PODBA, PORSL, and PODSL. And just as a reminder for the transaction section, we're proposing to leave PODBA and PODSL fields as they are. For the contract section, what feedback do you have for our proposed changes to PORBA, PODBA, PORSL, and PODSL? What are the challenges filers are having with reporting these fields currently? Do you have improvements to the proposed definitions? And for data users, do you use these fields for your analysis? If so, how? For the transaction section, we'd like to hear what feedback you have about our proposal to keep PODBA and PODSL unchanged. And do you have any comments for staff on reporting or using PODBA and PODSL? Please note that for those of you who've downloaded a copy of this presentation from the FERC website, we've made a few corrections to typos on this slide, so it differs a little bit from what's posted. Okay, so Rob, you should have presenters' rights now.
Marina, you're going to actually have to make me host. So if you right click on my name.
Yes, just a moment. Okay, you should be host now.
Excellent. I'm going to give the presenters back to you so you can keep that slide up. Okay?
Okay, yep, thanks.
Hey, Barbara, you're one of the few you're actually the only one with your hand raised. So I've unmuted you. Go ahead.
Hey, can you hear me?
Yes.
Okay, great. And there may be a problem. I sent a note to eqr@ferc.gov. It took me a while to even figure out how to raise the hand. It was not showing on when I opened it, but I just started. I think it was when I clicked on participants and scrolled down, it opened up. But when I just as is, it didn't show up on my screen. But I have a question about this. I also have a question about the introductory thing with the fields that you talked about putting away. On this one, if you want to exclude energy sales from the contract data for Podsel and Podba that use the same field names in the transaction data. That's going to be confusing because they have different definitions. And so I think it might make sense to somehow make it more clear in the contract data that it only goes for transmission data.
You think you were just cutting out just a little bit there, Barbara?
Okay.
Can you just restate what you mentioned just now?
Sure. Yeah, if you're having two different definitions between the contract and the transmission data, then I think you should name them different things, because I think it's going to be a little confusing if it only relates to transmission in the contract data, and if it relates to energy sales in the, I might misstate that. If it only reflects transmission in the contract data and it only reflects energy sales in the transaction data, then I think it would be helpful to have different names.
Okay, I see what you're
Also,
saying.
if there was any, okay, and then for the point of delivery specific location, I would love it to be a little bit larger. Sometimes we have to really squeeze, the interconnection of the XYZ plant and the system of blah, blah, blah. It's hard to get that into 50 characters. So if you're starting from scratch on some things, I would say raise that to maybe 70 characters or something.
Okay, thank you.
Hi, Marina and Barbara. I'm going to unmute a couple more participants that have their hand raised. So Jennifer, you're going to be unmuted. Jennifer Key, you're unmuted now. And also Renee McDonald, you're also unmuted, so you can participate as you wish. And I think you may be able to control your mute at this time, but we'll keep you unmuted unless things kind of go sideways with so many people speaking.
Okay, this is Jennifer. Can you hear me?
Yes.
Yes.
You're
Okay.
fine.
I had a question on the, I guess, the parcel field on the points of receipt, specific locations, and that has to do with, many network service agreements can have dozens or hundreds of specific points of delivery, and I think that's why the field is so rarely used, as far as I'm aware, by most transmission providers providing network service, because their individual network customers, particularly a large G&T cooperative, can literally have 200-300 separate points of delivery. So I'm trying to understand, is there something changing here? Should those people continue to, I think most probably leave it blank. Obviously ISOs and RTOs are in the same bag. They have NHTSAs where there may be, dozens and dozens of delivery points for a specific customer. They may be listed in the, some of, depending on the RTO or ISO, they might be listed in the contract. I'm thinking like SPP NHTSAs in particular list hundreds of delivery points, or at least dozens of delivery points frequently. So that was my question of just how was supposed to someone fill out that field in that situation.
Marina or Sohaila, do y'all have input on this, or is there any other PERC staff member that has a response for Jennifer, or we can take that back?
Yeah. Hi, this is Sohaila Mansouri. Jennifer, is it the problem, if I understand it correctly, the problem is like there is not enough space to put several of the point of delivery or receive?
Well,
is it?
Yeah, I mean, my understanding is, almost nobody fills this field in for like network transmission service. anyway, but, and I, assume one of the reasons is, it's just network, that it's network service, there's too many delivery points to fill anything in that you are, I mean, I can't say why people don't fill it in, but I do notice that people don't fill it in. But, you can have a typical contract that says, that lists, a NHTSA would typically list all the delivery points of a wholesale customer for network service. And usually, unless it was a very small customer, there would be anywhere from dozens to hundreds.
Yeah. So
So
do
I
you
don't think
think
anyone understood this field to mean like delivery point. And I just guess what I'm trying to understand is, what does this mean where you have, obviously there were always 50 characters and the people who had, so what does the field mean for network service? Can you just put the B? I mean, I think people would put, if people put anything, maybe it was the BA or, the name of the customer they might put, but they can't possibly list all the delivery points.
Jennifer, do you think it's they can't possibly because of the burden of putting them in, or do you think it's because the current system doesn't allow for something that long to be put in, like that long of text? Do you think it's more, do you think filers have more of a problem with the burden of providing that required information to FERC, or do you think it's more about that it just doesn't fit in the field?
Well, I can't speak to why filers do what they want, but do what they do, but certainly they couldn't fit it in if they want to, and the burden delivery points, change and are added and subtract. I mean, the burden would be immense if you had to put in all the delivery points, especially on the RTOs and ISOs.
so do you think if we give them ability to add multiple point of delivery or point of receipt on the same field, and probably they can like separate them with colon or semicolon or comma, then it's gonna be like the better option?
I think the burden is, I would think the burden is so immense that, people do what they do today, is not fill it out. Because it's
Am I still muted?
What?
Am I muted?
No, you're not muted.
Okay, it shows my microphone muted and the icon, but I think what I do with my clients is, it's partly the burden, but it's also would be pointless to add everything. It's just a fluid thing. So I might put interconnection points between customer in the blah, blah, blah balancing authority or whatever the footprint is. And so I describe it because it would be impossible and pointless to put, 50 different points in there. I don't think it gives anyone information. If it's network service, it's just where the service provider interconnects with the customer. So I just put in a description. Do I think 70 characters would make that better than 50 characters? Yes, but and I'm not sure is the delivery points or the potential delivery points are listed specifically. So that might be another, it's not just that someone doesn't want to do it. It may not even be included in there. So I don't want to imply that anyone that is reporting network service that leaves that field empty is not being compliant.
Yeah, no, and I agree with Barbara, and I think obviously people would immediately take out all their delivery points from these agreements if they were required to list them, because obviously they're not required to be there. So, if the burden was there to list them in the EQR, they would then take them out of the contract.
Okay, Renee, you're unmuted. Do you have anything to add on this, or something that you want to, Renee McDonald?
I kind of agree that to add it would be a burden for sure. And I think sometimes the field may be left blank or multiple because there have been so many answers that I believe guidance in the past was that if you can't necessarily list everything or if it's not defined, that you leave it blank. And then the last point I want to ask is, can you please explain transmission related product? I just want to make sure I understand what you mean by that.
Hi, Renee. This is Maria Voris. I'm on the FERC team. So I think one example where we do see these these fields being used for a transmission related product would be, for example, transmission capacity reassignment data. That's one area. And there are some transmission related products like interconnection agreements, for example, where you may not have all of these fields specified. And if they're not specified in that agreement, then we would not require that to be reported, just as is the case now.
Okay.
All right, if there's anybody else that has any comments on this, we can wait a minute or two. I don't see anything in the Q&A. But Marina, I'll leave it up to you to move on with our break, which I believe is next, or the next slide whenever you're ready.
Okay, thanks, Rob.
Jennifer, actually, Jennifer, you still have your hand raised. Do you have anything to say, or do you want to?
Sorry, I don't think I put it. Did that put it down? I'm not sure. Hold it.
Yeah. Oh, we have someone else that jumped in. Sherry. Sherry, I'm going to unmute you now. I'll mute the three previous participants if they're not already muted. Go ahead, Sherry. You're unmuted.
Hi, thank you. My question is actually on the ident file. I think we started that in the beginning. And are you going to talk about that anymore, about pre-populating those files from your company registration? Or is that not?
For this presentation, this is Sohaila, sorry. For this presentation, we are not talking about that anymore. But if you have questions, just go ahead and ask your question.
Oh, okay. Well, I can send it in. I just wondered how that was going to work because, we have multiple filers and we have a company email address used in the company registration. So it was more of how it's going to work in the ident file for that, since you have a specific email in the ident file. But I can send in the question if that's not in this presentation.
Sure.
I mean, I think that the reduction, or at least the removal of having to enter this in manually, it's going to be possible because the CID is linked to each individual company. So the database will basically be able to retrieve information using the CID as the unique key. And I'm not sure if that kind of answers your question, or if you had sort of a follow-up after that.
No, I understand it will retrieve the information. I just know the email address in our ident file is not the email address we use in company registration. And we have multiple filers listed in company registration. So I didn't know which one it would know to pick for the ident file.
Okay, I understand.
Yeah, I can send in the question if that's not for this presentation.
Sherry, that's something that we can definitely work out in an XBRL CSV format, or with the new system, is if there's another email address that needs to be attached to the filing or something like that, that can definitely be discussed. But I think to the point of us pulling the information from company registration is that would at least decrease much burden if there's something that needs to be added to it. More information that's not in company registration or different information, that's definitely something we can discuss when we get to an implementation, or actually figuring out specifically about what that would mean. So please, yeah, send your question or your concern to eqr@ferc.gov and just kind of write out the scenario that you're in, your fact pattern, and we'll make sure to keep that in mind as we go through this in in defining what field, or if there's an optional email field. We can do all of that type of stuff when we get there.
Okay, great. Thank you.
All right, I'm going to put you back on mute. Sherry, if you could lower your hand until you have another question, that would be great. And Carla's added a question into the chat, and I'll read it out loud for everybody. I don't know. I don't think that I think it only goes to panelists. It says, why require PODBA or PODSL in the contracts file when you're already requiring it in the transaction file? So is there a FERC staff member that wants to jump in on that?
This is Maria again. So I think what we see for most of the transmission and transmission related agreements is that they are reported in the contract section alone. There are obviously situations, where that's not the case, but that's why we wanted to make sure that we were at least capturing that information for the transmission and transmission related products. For the products that are energy related, for example, because they're also reported in the transaction section, then we capture the PODSL and the PODBA information in the transaction section.
Carla, I hope that answered your question. We can unmute you if you have another follow-up. Just raise your hand if it needs. Oh, I see a thank you. So we're all good. And Haley Franco, I see your hand raised. I'm going to unmute you now. Go ahead whenever you're ready, Haley.
Hi, I'm just following up on Sherry Parra's comments about the importing from the CID, which I think is a great idea, the ability to pull. The one question I have, which is kind of building on what she was saying, is that there are a lot of companies that have distribution distribution emails tied to the company information. And so that email may not actually may not match with the filer necessarily, or may not I think there's maybe a concern whether or not that information will pass the validation, I guess, or is going to be tied to the right company, because there's going to be 30 people in that distribution group, as opposed to tied to an individual that might be responsible for submitting the EQR. And then on top of that, sometimes a lot of companies, for their company information, they've used in the past law firms that are assisting the client or the company on regulatory compliance, not actually the company information. So there's a little bit of a disconnect there on some of the company information, and I'm not sure if that's something you guys have thought about or may raise issues when importing that data into the EQR.
Yeah, this is Sohaila Mansouri. I think we're gonna consider that, and we're gonna look into that to see how does it gonna work. But most likely the CID is gonna be the unique key between those systems. And if you have to, as Rob said, for the new system, you can add extra information or make it optional, or somehow we will make it unique to grab the data from other systems. But definitely we're gonna consider and review those situations.
Yeah, no, that'd be helpful. Thank you.
Sure.
Excellent. Thanks, Haley. If there's anyone else who wants to speak up or add any questions in the Q&A, that'd be great. Just a reminder. Oh, Lisa, but just a reminder, staff is not going to be monitoring the chat box. We will be addressing the questions that are put in the Q&A. The chat box is for panelists, or not panelists, for attendees to chat back and forth with each other if there's other comments and things like that that you want to make, just publicly or anything on topic. We will review it later, but we're not actively monitoring it now. So Lisa, I'm going to unmute you right now, and go ahead, Lisa.
Can you hear me?
Yes, we can hear you well.
Okay, for transmission related products, do you mean only transmission contracts? Is that what you meant, to contain this information and not energy contracts? It will no longer be, I'm not sure that's what you meant by transmission related products. Is that you'll only complete the fields if it's a transmission contract point to point network?
So, hi, Lisa. This is Maria. I think the intent so there are some contracts, like you said, point to point, the network service agreements, for example, that are transmission. There are some that are considered more transmission related, like interconnection agreements. But we're not thinking that, an energy contract, for example, would be a transmission related contract.
Thank you.
Thanks, Lisa. If that's it, I'm going to mute you back if you want to lower your hand. If you're finished. If not, I can unmute you again. I'm sorry. I may have cut you off too quickly. Okay, Lisa, I've unmuted you. Did you have a follow-up? I apologize.
No, I'm technically challenged. How do I lower my hand?
The same way you raised it. There should be, just go back to that same button, and it'll lower your hand.
It's just not doing it. Hang on. I'm not sure why.
Hey, Jennifer, you're unmuted and ready to join in. Lisa, I'm just going to mute you, and it'll be no problem.
I think based on the questions and the confusion, the definition might be better if it referred to, I don't know, transmission products that have a point of receipt or point of delivery, because obviously interconnection, there's so many types of interconnection contracts and construction contracts and transmission related contracts that don't have points of receipt and points of delivery. The vast majority of transmission related products don't have those. You mentioned as a transmission related product reassignments. Well, reassignments are transmission. I mean, to me, transmission and transmission reassignments are both transmission, and they are things that might have PORs and PODs, but anything that's sort of a product that doesn't move from one point to the other, isn't covered by this. So it might be clearer than, rather than saying transmission related, is saying, or a transmission related product that has a point of receipt and point of delivery, in the, just because I think people are confused by the notion, because there's only very few types of contracts that would have that are transmission related and they would have a POR or POD. So just a suggestion.
Okay, thank you.
Thanks, Jennifer. I don't see any more comments or questions or hand raised. We'll give it another minute to about 10:50 just to make sure no one else comes up with anything. And then Marina, I think we have a break next. Is that correct?
Yes, that is. We've got a 15-minute break here. Let's resume at, let's say 11:05 East Coast time.
Okay.
Hey,
great.
Hey, Rob, this is Jeff. Hey, I just want to just chime in here. This is Jeff Sanders. If folks do have specific scenarios that may be unique to your company relating to the company name, email, zip that we suggested come from the CID file, please let us know, because we know with the vast number of EQR filers, there could be situations that are unique to one company that another company might have. So if you think of something that might affect you and it may not affect others, please let us know so we can consider that. You can either email in or if you want to bring it up in with a question, where we love the feedback. Thanks.
All right, everybody, we're going to go on break. Here's this screen will stay up through this, so feel free to connect or disconnect and rejoin again. All of those things will work, but we're obviously going to leave this up for the next 15 minutes, and we'll talk about contract execution date when we come back.
Okay, welcome back from break, everyone. Let's get started with the next field. We're going to talk about the contract execution date, field number 21. Okay, team, is everyone back?
Yeah, Marina, I'm here. You can get started.
Okay, great. The contract execution date definition is shown on the slide on the left side. It's defined as the date the contract was signed. If the parties sign a different date, use the most recent date signed. So we propose to modify the definition by adding the bold text on the right side of the screen. So the new definition reads, the contract effective date granted by the commission. If contract was not filed for commission approval, then use the date the contract was signed. The last sentence remains the same in the definition. The content in the original definition remains the same, but the new bold text adds clearer guidance for unexecuted contracts that are submitted to the commission for approval. And in order to capture that, we also propose to change the field name to contract effective date to shift the focus away from when a contract was signed to when it actually became effective. So this was a really quick presentation on that field, but we're going to pause here for our second discussion now. What we'd like to hear from you is, what challenges you're having with the contract execution date field and what changes you'd like to see to this field from the perspective of a filer or a data user. We'd also like to know what considerations staff should be mindful of if we make the proposed changes to this field. And finally, if you perceive an interdependence between this field and others that you'd like to bring up, then please share those thoughts.
Hi, everybody. Again, if you could raise your hand by clicking the hand raised feature. I see Barbara. We'll get to you first in just a second. And if you have any typed questions that you want to put in the Q&A, that'd be great. I'll read them out loud and we can get to them too. Again, the chat feature is open for you to discuss anything here amongst yourselves. We're not monitoring it for questions. So actually, I'm going to unmute Barbara first, and you can talk. And Renee, you may want to add on to Barbara's stuff. So I'll get ready to unmute you next. Go ahead, Barbara. You're unmuted.
Thanks. I have a concern with the name change because I think the overwhelming majority of contracts that are reported on the EQR are not filed with the commission, and the commencement date, the current and even somewhat the proposed commencement date of contract term definition of that is effective date. So I think by calling the execution date the effective date, I think that might be confusing. Possibly just to call it the contract execution / effective date or something. So because I think in at least 95% of the cases, it's going to be the execution date, not necessarily the effective date.
Thanks, Barbara. Is there any FERC staff that want to follow up with questions or anything about this name?
I'm sorry, you broke up for me when you were talking. So
Yeah, this is Sohaila Mansouri.
No problem. I was just asking FERC staff for them to chime in.
Oh, okay.
Yeah, Barbara, can you hear me? This is Sohaila Mansouri.
Yes.
So in regard of the commencement date, we're going to discuss it next. But do you think if we change the definition on commencement date to refer to the, instead of contract execution date, to effective date, or change it, is it going to make it easier to use it?
I looked at
Because
the
you refer
changes
to
that
the-
you've proposed for the commencement date, and I don't, I just think naming the execution date, what's currently the execution date field, the effective date, it seems like it's redundant with the definition. It would be clearer to filers because there are a lot of people that sadly don't read the data dictionary when they're doing this, and they look at the name of the field and they put something down. And if the definition for, I'd say at least 95% of the contracts that are going to be reported is what is the execution date, then I would, I think it'd be more helpful to have execution date in the name. The other both the EEI and the ISDA with Power Annex generally don't have a signature dates. So you may want to add to the definition, if there are no signature dates in the contract and it's not filed at FERC, it should be the stated execution date expressed in the contract.
Okay, thank you.
Thanks, Barbara. I'm going to put you back on mute, but you should be able to control it yourself. And I'm going to, Renee, you're unmuted right right now.
I agree with Barbara's comments that it would be confusing since the effective date is referenced in the next field.
Thanks, Renee. I'm going to, you've disappeared from my list for a brief second. So if you could mute yourself back, that would be great. And we'll get to it in a second. I'm going to read a couple of questions that we have on here. Joy May Chipman asks, isn't the commencement date the effective date? Maria, Marina, or Sohaila, would one of y'all like to answer this?
I mean, sorry, Maria, were you?
I was just going to say maybe we can look at that with I think that's one of the points that was just raised on the commencement date. Maybe we can look at it with the slide having to do with a commencement date. I mean, we wouldn't want to confuse people, obviously, so we'll take these suggestions into account in terms of, you know, referring to effective date where that would be applicable, or execution date where that would be applicable.
Excellent. Okay. Sherry also asked a very similar question. And so we'll get to that in a second. And then there's a couple more comments about also agreeing that the panelists can see with the comments that have already been made. So I think there's some more hand raised. David, I'm going to unmute you now. David Smith. Oh, David Smith, I think you lowered your hand. If you do have something to add, David, you'll go. Oh, there you go again. Give me just a second. Okay, David, you are unmuted now. Go ahead.
Yeah. All right, I jumped the gun there. I just wonder what value this field has at all. All it does is confusion, and it doesn't really tell you anything except when a bunch of people got together and signed a contract. What does this give us that the execution date or the commencement date doesn't give us? That's all.
Excellent. Thanks, David. I'll try to find you again, but if you may need to be able to put yourself back on mute. Is there someone that wants to address David's comments from FERC staff, or do we want to continue on?
So this is Maria. So Dave, can I ask a quick follow-up? So your recommendation is that we not change the contract execution field at all? We keep it as it was before. Am I understanding that correctly?
My thought is to eliminate it altogether.
I see.
I do not understand what value it offers other than confusion.
Okay.
So David, this is Sohela. So you're suggesting to remove the contract execution date, but still keep the commencement date, or remove both?
I would keep the commencement date because you want to know when the contract came into effect. But I don't see a value of seeing a contract was signed by all the parties. That's all.
I understood. Thank you.
I'm going to read a comment that Candy Hahn made in the Q&A. With interconnection agreements, her company reports the execution date and the effective/commencement date do differ. So mark that as answered, or at least put into the conversation. And Barbara re-raised her hand, so I'm going to unmute you, Barbara. Go ahead.
Yeah, I think there is a reason for the execution date, and like the last comment you just read, it can be different from the commencement date. And I think there may be, I'm not a lawyer, but I think that that might be one of the things that are required to be reported for a contract. If, you know, back in when the EQR was established, it was to avoid utilities having to actually put their contracts on file at FERC. And I think this is one of the data elements that was required to be included in the contract. And so by having it in the EQR, it fulfilled that. But I think that's true. So there may be a legal reason that you have to have it. But second of all, I think there is, because there is a difference between the execution date and the commencement date, particularly if the contract has been amended, I think there is a reason to have the execution date. And one of the reasons is when, particularly if it's like a power sale, you want to know when the terms of the contract were agreed upon to see if they are reasonable in the time frame. For instance, after the California Act signed for very high rates, and it wasn't necessarily because of market power, it was just a reaction to the situation. And we know in California the prices have come way, way, way down since then. So what might look like a ridiculous price now might have been very reasonable at the time it was signed. And I think for the commission to be able to judge whether a price was just and reasonable, part of that discussion is when was that contract executed. And then the difference between the commencement date of contract terms, particularly if there's been an amendment, were reported. But I think it's important to have the actual execution date in there too.
Thanks, Barbara. I'm going to read a comment that Joy May Chipman made in the Q&A and then make it public. I believe these are public. She notes that when there is an amendment, her company changes the commencement date and not the execution date. And I know Renee raised your hand. Go ahead, Renee. You're unmuted.
I'm similar to that comment. The fact that the commencement date can be updated with changes, I feel like you should have the original execution date for that time frame to say that contract was valid. Like if terms change, I don't know that I'm wording this properly, but Barbara kind of hit on it too, that all of a sudden you've got this new fresh date, but the contract's been in play for years. So I feel like that distinction needs to be there.
Thanks, Renee. I'm going to read a couple more comments through here and let people digest. And if they want to raise their hands and make some more comments, we'll do that. Same with FERC staff. Jump in if there's any questions or other comments that you want to make. But I want to read a few, and I apologize if I'm butchering or mispronouncing your last names. It's just I'm not the best at that. So Sherry Para also writes, isn't the contract execution date used for the trade date in the transaction filed? If required, would you need it? Correct, with a question mark. I'm going to make this public and we'll get to it in just a second. And she also adds on to that for bilateral agreements, for examples. Also, Rhonda Johnson adds in it also making the contract binding. And then Candy Hahn added in another question. It also have a bearing on the quarter in which an agreement should be reported. An agreement may be executed in the first quarter, but not effective until the second quarter. So in your Q&A, you all should be able to see these questions and comments, just to follow along yourself, and I'll invite FERC staff or anybody to raise their hand and we can continue on.
Okay, Rob, there's no more further follow-up. I can move on.
Sorry, I put myself back on mute. Renee, if you have something to add, I know you're still unmuted with your hand up. If not,
I do.
You do, go ahead.
I don't necessarily agree with the fact that the trade date is on the transaction file being the same as the contract. For the fact if you have an ISDA or a master agreement, then that agreement is in place long before the trade is executed.
Great, thanks, Renee. Marina, I think if you, it's up to you if you want to give it about another minute and then you can move us off of this and on to the next thing, or
Okay.
I'll leave it up to you. Yeah.
Okay, great. Well, so this part concludes my section of the presentation. Up next, first, thank you all for participating in the discussion. Up next, Sohaila Mansouri will discuss the contract execution date. And I think that presentation will flow really well kind of off of what people were commenting about. So I think you might get a little bit more information on some of these concepts coming up.
Okay.
And Sohaila, let me know if you're able to grab the presentation, right?
Yeah, you need to make me as a presenter.
Sure.
Yeah, I'm doing that right now. Give me just a second.
Hello,
Okay, Sohaila, you should be good.
Okay. Okay, good morning, everyone. Thanks for attending this TED conference. My name is Sohaila Mansouri, and I'll continue our discussion with reviewing the commencement date of contract term. The current definition for this field is shown on this slide, and I won't read the whole thing out loud, but I want to point out that one of our recommendations is to add one field to the list of what we deem to be significant fields. A significant field is defined as any field that changes the main term of a contract. We therefore propose to designating the customer company name field 17 as a significant field as well, which is shown in bold in this slide. We also propose to modify the definition for simplicity by adding the bold text shown on this slide, which states that if there are one or more amendments to terms in one quarter, then report just the effective date of the most recent amendment. Then we would delete the sentence immediately following, since the concept is captured in the preceding proposed new sentence, and that's shown here in strikeout. One additional modification to the commencement date of contract term is to add a new validation to enforce an existing requirement. Currently, there's a requirement that if one of the significant fields change, then the filer needs to report a corresponding commencement date of contract terms. But right now, there is no validation that enforces this requirement. This is a limitation of a system that's in place, but the potential of an XBRL CSV filing format would allow us to design the new EQR system to compare data quarter over quarter for all the significant fields. It would be able to detect a change in the significant fields and when it occurred. We therefore propose a new validation that if one of the significant fields changes, then the commencement date of contract terms must be updated to reflect the date in the quarter that the change became effective. If not, the filing would be rejected. Automatically checking the data and enforcing the existing requirements for this field makes the data collection more accurate and useful for analysis. As the system currently exists, when the commencement date of contract term is reported, it may be difficult to identify what components of the contract change, which of the significant fields were modified, and which products were changed. We would propose to add a text field to accompany the new validation for the commencement date of contract terms. Filers would list the significant fields were modified in the contract in this field.
Oh, dear God.
So during our third discussion, we'd like to hear from you on the following topics. Is the proposed definition for this field unclear or confusing? What are the challenges filers or data users have with this field? What other changes would filers or data users like to see with this field to improve clarity? And what considerations should the staff be mindful of when making the proposed changes to this field? Do you perceive an interdependence between the commencement date of contract terms field and other fields that should be considered if we make changes to this field? So we would like to hear from you.
Thanks, Sohaila. I appreciate that. We're going to jump right into the discussion as we've done it all the time, but I'm going to start first with a written question that Rhonda Johnson put in the things. If a company's name was changed from a corporation to an LLC, would that be a reason to change the effective date, even if a formal amendment wasn't done? Is there, is the FERC staff want to take this, or do we want to take this back and answer it later? I'm going to ask to Maria if you have a comment on this.
Rob, can we take that one back for a second, please? Thank you.
Yeah, that's no problem. We'll take this back. We'll get to it in just a second. I'm going to drop into with Barbara. Barbara, you're unmuted. Go ahead.
Thanks. I'm going to try to be diplomatic, but I dislike almost everything that's been proposed to be changed. The adding field 17, the company name, that was attempted by the commission a couple of years ago, I think it was, whatever the order, and many of us requested rehearing and saying that it didn't change the effective date of the contract, and the commission ruled with the rehearing and granted rehearing. So I'm not sure what has changed in the last year or two since that ruling, but since the terms don't change, and I mean, you can go back and look at all the reasons that I know I requested rehearing, and there were several others, said that field number 17, the company name, should not be included, counterparty name, whatever it is, should not be included in changing the new language for the amendment. I don't, I guess it's okay. I don't think it's any clearer than the stuff that was struck out. And the having an error if a significant change was made and the dates weren't changed, I think that's going to be a lot more problem than solution. Because if someone, for an example, I have a lot of solar companies that and wind farms that I file for. A lot of times their termination, the actual termination date isn't known in the first quarter that I'm filing, because it is based on the commencement. And sometimes they start producing test energy well before the commercial operation date. So I will leave that the termination date, the contract termination date field empty until I can calculate it from the commercial operation date. So that means if I did that and I came in and added a contract termination date after 2 quarters, because that's the first time I actually could calculate it and I want to make sure the record's complete, that I would get an error, which then would mean that there's a lot more problems than it solves.
Hi, Sohaila. We had a question. Could we go back to the recommended change slide and get off the questions for a second? We know that we're talking about this, so.
Is it this one?
I assume it was the one before. Actually, Aaron wants the one before.
This is just a definition.
I think it may be the red line is what Aaron wants to see. These slides are also on the website for you to download. Marina, could you put the link in the chat so everybody can get to where they're saved on the website? I know that you mentioned at the beginning of the presentation, at the beginning of the conference, or today's conference, that there are some edits that don't track consistently, but at least they'll be able to page back and forth between them on their own. Would you mind doing that?
Yeah, no problem.
All right.
Okay.
Barbara, you're still unmuted, but feel free to mute yourself or jump back in, but I'm going to move on to Jennifer Key. Go ahead, Jennifer, you're unmuted.
I mean, I agree with Barbara, and I think one of the bigger problems with number 17, in particular, the counterparty name, is that, you know, there's 2 reasons the counterparty name changes. Either the counterparty had a legal name change, as someone mentioned before, such as a change from a company to an LLC, or an assignment. And while with an assignment, the person filling out EQR might have, you know, the effective date of the assignment, when all that's happening is the counterparty is changing its name, there's so many different dates. There, you know, the legal date that entity changed its name, usually with the state corporation commission. There's, you know, the date the counterparty happened to find out about the name change, which often is well after the name is legally changed. You know, there's, you know, you just don't, since the contract doesn't have to be changed when the customer's name changed, there's no, like, you know, there's never an amendment filed, or typically, I mean, a few utilities do file amendments when the customer name changes, but since there's no requirement, there's no official FERC date. So I think if you were going to have field 17, and I agree with Barbara for all the reasons that this has already been resolved and there shouldn't be a field 17, you're going to have to explain what date to use, particularly in the case of a counterparty legally changing their name, because that could be a huge amount of work if you're supposed to go and figure out when some, you know, whatever, whether it's an LLC, LP, town, city, you know, which might not even have a legal name, changed its name, you know, it would be very difficult to figure out, you know, what effective date that name change occurred on.
Hey, Jennifer, this is Maria. Can I ask a follow-up to what you just said, which is very helpful. Thank you. So to the extent that there is an assignment to a new counterparty, that would not constitute, or at least in your experience, that would not constitute an amendment to the contract?
No.
So even if there's even if there's a new counterparty, effectively.
Yeah, FERC ruled on that, God, 15, Barbara helped me, 10, 15 years ago, that you don't have to refile a contract if the customer's name changed, if the customer changed.
Okay, thank you. I just wanted to clarify that point.
Now that was customer name, you know, the customer can change.
Okay, thanks, Jennifer.
There are utilities that do file the name changes, but most, no, you know, you don't have to when the customer changes. Yeah. I mean, you have to change your EQR under the EQR rules, but you don't have to change the contract. You don't have to refile the contract because none of the terms have changed.
Great, thanks, Jennifer. I'm going to put you back on mute, but I think you should be able to control it yourself if you want to jump back into the conversation or just raise your hand again. And Renee, I see you have your hand raised. I'm going to unmute you now.
I concur with both Barbara and Jennifer that field 17 was discussed and ruled out. I also think adding a field to notate which fields changed would be burdensome in filing the EQR.
Okay, thanks, Renee. Rhonda Johnson's had a few questions in here, and I think some of the questions we're going down to. The last one, she said, "Are you saying no change to the effective date?" I think that we're discussing all the possible changes to these fields today. This isn't a decisional area. This isn't a decisional place to make a final decision in this tech conference. These are just the concern, the ideas. If that's not incorrect, Rhonda, go ahead, raise your hand. Maybe we can get, I can unmute you and we can get more to the bottom of what you're asking in your questions. I see that Jean Sun has raised her hand. And Barbara, you're still unmuted if you want to jump in, but I'm going to unmute Jean and take her question. Go ahead, Jean.
Hi, my name is Jean. I have a question regarding, field 22. You have regarding that commencement date of contract terms. And later you said in the next slides you said this field would be required when a significant field changes. And when what does it mean? What are the significant field? And does it mean currently the commence date of contract terms it's not mandatory? I'm just a little bit confused.
So this is Sohaila. Yeah, the significant field is listed on the definition. Currently there are field 18, 23, and 25 through 44. And right now, currently, this is if any of those fields are changes, then is this commencement day is a required field. But currently, what we are saying, this is the existing validation, but existing requirement, but there is no validation currently to enforce that requirement. So that's why we are considering to adding the validation to enforce the existing requirement that is currently in place.
Yeah, so you want to have the commence date of contract terms to be mandatory, is that right?
If any of those fields, significant field is changes, and this is a existing requirement, is not the new requirement. Yes, it should be mandatory.
Yeah, so significant field changes, could you give us some examples?
Like any of those fields, like field 18 or
sorry, so what is the field 18? You mean?
Okay, field 18 is contract affiliate. Field 23 is commencement, or it's field 23 is contract termination date. For example, 25 is the extension provision description, and then onwards through field 44. I won't read all of those off, but those are available in the data dictionary that should be that you can download off of our website.
Yeah, it's just I don't have your data definition in front of me, so it's difficult to know like the numbers and corresponding column names. Okay, I think I know what you try to do. You try to make it.
Yeah, Bob, go ahead. Rhonda, I've
Okay.
unmuted you too.
Okay.
I know that you wanted to jump in here also. And
Yeah.
Jennifer, I'm going to unmute you also. So we'll just have a discussion. Just, you know how these things go.
Okay.
Go ahead.
I think part of the confusion may be that we took these two slides and addressed them separately, and if the changes are going to be made, they would have to be made in both fields. So if you were going to talk about the significant fields, at least in one of the definitions, those fields that are listed, the 17, 18, 23, and 25 through 44, there should be some sort of parenthetical, that's what you're calling significant fields. I don't think you want to have a definition with significant fields, which would imply that all of the other unnamed fields were insignificant. We wouldn't want to hurt those fields' feelings, but so maybe that will help people. The other thing that I didn't address in my original text field to list the significant fields that were changes, I think that's a train wreck. And it seems to me if there is an updated commencement date of contract terms, i.e. effective date, then you would be able to look between one quarter and the next quarter to see which fields are changed. I just don't understand how that's that complicated, that you have to have a whole field, and it just seems like an invitation for more problems.
Yeah, thanks, Barbara. That's a good point, and we can look into this.
All right, Rhonda, I can unmute you again if you want to ask the questions, and then we can get to Jennifer Key. Go ahead,
Okay.
Rhonda.
Can you hear me?
Yeah.
Okay, great. My question is on field 25 regarding the extension provision description. So in many cases, like if you have like a EEI or is it with the power annex, many of those contracts have a termination date, and then and you have to send in a written notice or something in order to terminate, and other than that, it's ongoing. So oftentimes they put in evergreen. So it also has, therefore, the termination date. Is the extension provision description necessary? Because if you have a termination date and you go in when the term actually terminates, is it necessary to have an extension provision description?
Actually, this is the discussion on the next slide, and we are discussing the termination date very like on more detail on the next slide.
Okay.
Yeah.
Okay, Rhonda, we'll get back to that on the next slide. I'm going to put you back on mute. If you want to lower your hands until we get through a little bit of that, that'd be great. Linda has a question that's more just specific about the termination date. Linda Roberts has it. She asked, does the contract have to be formally terminated before the actual termination is reported?
Yes.
I'm going to ask if any. Go ahead, Maria.
Yeah, those are the questions that we are going to discuss on next slide.
Okay.
We have a whole long discussion for termination date.
Okay, I think we're pretty good here. I don't see any more questions in the Q&A. I don't see any more hand raised. So Hala, if you want to give people, a couple more seconds if they had any more comments on this, and then you can move on.
Yeah, sure. I will wait a few more seconds.
Up to you whenever you want to move forward.
Okay. Now we are going through the discussion for the contract termination date. The contract termination date field, as it is currently defined, is meant to capture the termination date if it's specified in the original contract or an amendment contract. Often we see that this field is left blank, and currently there is no validation to check if it should have been filled in. We think that as the field is currently defined, could be merged with field number 24, the actual termination date. The idea behind merging them would be to simplify the burden of tracking the same concept in two different fields. Ultimately, what we want to capture is whether a contract is still active, and if it's going to terminate, what's the date of termination. And the current definition for the actual termination date is the date the contract actually terminates. This field is required if the contract is terminated, but is often not reported, and the current system's limitation prevent validation from being created for it. We therefore propose to remove this field, and like I mentioned on the previous slide, we'll modify the definition of the field 23 to capture whether the contract is still active. What isn't captured in these two fields currently are three concepts. One is, what do you do when an evergreen contract thinks there's no way to currently make that distinction in the EQR? Second is, how do you reflect a termination date change due to an amendment or multiple amendments? And third is, what do you do when novation occurs, when a contract is transferred to another party? This slide covers our proposed validations to address these issues. To give a better idea of what we're talking about when we use the word novation, I'll describe an example. Let's say there are two parties to a PPA contract. What happens when a seller company is either bought by another entity or merged such that it is no longer the seller specified in the original contract? In this example, if all parties agree, a new company may take on the rights and responsibility of the original seller under that contract. Our proposed definition for novation is the substitution of a new contract for a previous contract with the consent of all parties, usually resulting in the transfer of rights and obligations of an original contracting party to a third party. In order to improve the data quality, we propose to implement some accompanying validation for the contract termination date. The first modification would be to add a new evergreen option for terms name in field 27 and field 60. Evergreen would be defined as a contract with unlimited duration. A validation could check if a filer submits an EQR where the contract termination date is blank or NA. And if the term name is evergreen, then the system accepts their filing. On the other hand, if a filer forgets to check evergreen on the term name and tries to submit a filing without a contract termination date, then their filing would be rejected. Next, we would create a new field called novation, with a simple yes or no option, which would capture novation from the perspective of the EQR filer. If the contract is novated, the filer would make yes. If not, then they mark no or leave it blank if it doesn't apply for a given contract in a given quarter. If the seller transfers the contract to another owner, then the field would be marked yes in the final quarter that the contract is being reported by the original holder. In addition to the proposed novation field, we'll also propose to add a text field to accompany the novation field. The current owner would fill in which party is going to be assuming the contract responsibility. If they mark yes, that novation is happening or occurring. Recall the example I mentioned on the previous slide, where a new owner takes control of a PPA, the old seller company must mark novation equal yes, and the contract termination date is left blank. That tells us the contract is still active and future EQR reporting responsibilities for this contract lie with the new party. The new party would then report it following the same process as other new contracts. They'll create a contract ID following whatever convention they prefer for assigning a contract ID. Alternatively, filer could use the extension provision description field number 25, to add information regarding the new responsible party. This is an unrestricted text field. The point of these proposed changes is to allow the EQR to track a contract over its lifetime and allow transparency when a contract transfers ownership. Hopefully, this make it easier to track changes to the contract termination date quarter over quarter. And for the discussion on field 23 and 24, we'd like to hear from you on our proposed modification. How often have filers or data users seen a scenario where a contract is not evergreen and doesn't have a contract termination date? How often are contracts novated? For example, sold or transferred to another party with a different CID. What types of novation are there? Is there a novation scenario that wouldn't be captured by our proposed changes? Is there an interdependence between the contract termination date and actual termination date and other fields that should be considered when making changes to this field? What are the challenges filers or data users have with this field? What changes would filers or data users like to see with this field? What other considerations should be kept in mind when proposing changes to this field? Those are a lot of questions. Hopefully, we get some answers from you.
Thanks, Sohaila. I'm gonna interrupt right here and go back to a logistic question. So, and ask Jeff Sanders to respond. In addition, Victoria writes in the question, in addition to making the recording of this meeting available online, would it also be possible for you to post a transcript for folks who are hard of hearing and or having difficulty hearing due to technical issues? So Jeff, if you could unmute yourself.
Thanks, Rob. We're not planning on offering a transcript for this, but we are recording it, and the plan is to have the recording available on the FERC website under the EQR section, have that be available after this conference so people can go back and listen to it. Hope that answers the question, but we're not planning on making a transcript of this tech conference. Thanks, Rob.
Thanks, Jeff. Barbara, your hand's raised and you're unmuted. Go ahead.
Okay, thanks. it seems like there's a lot of points here. So just running through the question. Well, before I even go to that, there was some discussion of termination and the difference between actual termination and contract termination date. And the contract termination date is obviously when the contract is set to expire. And so most often that is left blank because there are a lot more master agreements than PPAs, which would include that. But getting rid of extension provision because it didn't serve a purpose. And I think there is a purpose if there is language in the contract that talks about pricing arrangements after the primary period of the contract is terminated, then I think that rates, I think legally that needs to be on file. So I don't think just getting rid of that would be helpful. I think there are contracts where there's not, there may be a termination that's discussed in terms, like if it's something that is going to go until XYZ happens. And so you don't have a firm termination date because you don't know when XYZ is going to happen, but it's not an open-ended contract. And so there is a specified way that contract's going to end. So I think that, that answers the first question. I'm concerned about all the novation discussion often at all. And it seems like when you're talking about novations, it's you're only talking about novations where the filer is novating that contract to a different counterparty, but not, filer is novating it to a different seller so that they won't be reporting it anymore. But there are also contract novations where the purchaser is being changed for another purchaser. So I'm not sure how that fits into this discussion. Scenario that wouldn't be captured by our proposed changes. And I think what I just described was. And I also think that just waiting until a contract terminates to put in an actual termination date is a problem, because I think from a user standpoint, looking at the EQR data, there may be a reason you want to know when someone's contract terminates. And if that stated termination date is not in there, then a party wouldn't know until after it providing service to a muni and their contract's terminating in 5 years. If someone else might want to provide that service, it would be helpful for them to know when the current party who is selling to that customer, that when their contract ends, so they can go try for that business. So I think it helps from that way. And then the actual termination date, what I would suggest changing in that is just not having the definition be the date determined, to the date the contract actually terminated, because the way it is now, you're only supposed to fill that field in after the contract is over. And I just would suggest the whole novation thing, I think that's a lot of challenges for what, in my opinion, and others certainly are welcome to jump in, I just don't think it happens that often. And I think some of these questions that are being raised and that there's solutions could be dealt with just changing the extension provision field definition to include more data. And just like, if there's a novation noted here, I've asked clients to put notes in that field because it's a free-form text and pretty large field when they do make a change, just so if someone's looking at their EQR, they can understand why a contract suddenly disappeared if it was novated. And so I think that's a way of solving this without. Thanks.
Thanks, Barbara. Regarding that termination date and actual termination date, to fill it up, but if we are combine this, we are suggesting if we combine these two fields on one field, so it's going to be one field as a termination date. The originally, when the contract is not actually terminated, we put the filing, put the termination date that as it is in the contract. And when is actually terminated, instead of adding the new value on the other field, actual termination field, they just change the termination field, the original termination field, on that one field. So it's always have the latest termination field that is available. That is so it's always there are some values should be on that field, one field, either the original termination field, and if there is a actual termination field that is different, then the filer should update that field.
Say there always should be a value in that field. If it's an open-ended contract, there would not be a validation in that field, any data in that field,
Yeah,
correct?
Sure, except for those scenarios that we said for evergreen or for novation.
There are
Yes.
occasions, it's not very common, but it's not completely infrequent, where the contract termination passes, the contract termination date, the stated contract termination date passes, but it doesn't actually terminate. And service is continuing negotiating new terms, and they haven't come to agreement yet, and they just agree to continue under the old terms until they come to an agreement. So you would have an EQR that says it's terminated, and if you're reading it the way you're saying, you would look in and say, oh, well, that termination date was last month, so this contract must be over. And in fact, they're still providing service under it. So that would be an issue. There's also the question of, is there an FPA requirement termination date to be included in there, which I guess now that I'm saying it out loud, I'm realizing what you just described would take care of that case. But I think there are times when a contract termination date is passed and the contract doesn't actually terminate. And then the other issue, there are some contracts which say, this contract will go on for 5 years, and then every year it will automatically renew unless, notice is given with 6 months or termination date. And by using the extension provision field, you can see, okay, the original contract termination date is passed, but based on what's written in the extension provision, that contract is still ongoing on a year-to-year basis. And so I'm not sure how you would address that. Would someone have to go in and then change their contract every year when that date passed and add a year to it, which then that's kind of a pain to have to go in and change that contract.
Okay. Thanks, Barbara. I'm going to add in a clarifying question that Haley Franco asked in the chat, and then we can get to Jennifer Key next. But Haley asked, is the novation intended to capture successions, i.e. a name change of an existing party to the agreement? The CID for the party with the name change would remain the same. I'm going to say this is answered verbally and ask Sohaila or some FERC staff to address this.
Yeah, I refer it to Maria.
So Haley, I think the way we were envisioning the novation is where it would be actual, the new party would take on the rights and responsibilities of the original counterparty, and where the CID could in fact change, so that the seller would be a different seller than what was specified in the original contract. I think that's the scenario we had in mind with the novation.
Yes. And if we go back to the slide,
Well, Sohaila gets us here. I'm going to say, Jennifer, you're unmuted. Rhonda Johnson, I'm unmuting you. And Renee, I'm also going to unmute you, or at least give you control over your mute buttons. So feel free to jump in on the conversation. And I know you probably had other specific questions or comments too.
This is Jennifer Nonge. Well, almost everything I agree with Barbara as usual, but just to answer on the first question, how often is our contract that's not evergreen, it doesn't have a contract termination date? On the transmission side, it's extremely common because of construction agreements, delivery point agreements, facility agreements, where you're agreeing to build something, no one really knows how long it takes. Yes, the contract should terminate after whatever you agreed to build for the other party is built and energized, but virtually none of those types of contracts actually have termination dates in them. They're not intended to be evergreen. They're intended to be terminated, when the project is built, but they don't even have provisions that say, oh, we'll go in and terminate this when the project is built. They just don't deal with termination at all. So you have lots of contracts, I think, on the transmission side that can fall into number one. Moving on to the novation, which I have very serious concerns about, because novation is a very legalistic concept, and a typical person filling out an EQR, I don't think typically has the legal knowledge or training to understand what a novation is. And as my understanding of the proposal here is that for the maybe, handful of novations that might occur that are legally novations, you'd have, thousands of sellers have to go in and hit no on what may be hundreds or thousands of separate contracts that they're not being novated. Obviously would stay the same every quarter, but novation is just so rare. And the big thing is novation means the original contract is gone. And obviously, if there is a novation, the original seller is going to take it off their EQR. The new seller is going to give it a different name, going to, put it on its EQR, do whatever it needs to be. But why FERC would need to know that there's any connection between the two contracts, because legally with a novation, there really isn't any longer a connection between the two contracts. Yes, the counterparty and the terms may be the same or similar, but those contracts aren't legally connected to one another. And this seems like, adding a field for novation, that has to be filled out, on the first time the field is added is just a huge burden for almost no gain. And I don't think that the difference between understanding a novation versus an assignment, because typically when you're talking about the counterparty, I think none of those would be those are almost always assignments, not novations. And I just think you're introducing a very legalistic determination to something that is not very often filled out, by a lawyer, and would almost require, would require a lawyer to make a call as to whether a novation occurred. But the burden is so great compared to the benefit. And, if a contract goes away and a new one takes its place with a different EQR seller, FERC has all that information. It knows that other contract went away, just that the only thing not there is the linkage. Obviously, if there's a merger and one company takes over everything on the EQR of the other company, EQR staff could easily make itself aware of that and shouldn't be surprised to see, when one company is merged into another, which isn't that frequent, that, all of a sudden they have a whole batch of new contracts. So I'm just not seeing how the benefit possibly outweighs the burden on novations, especially given the legal nature of the term.
Yeah, I just, this is Sohaila again, just to clarifying, if there is no novation, if it hasn't happened, the filers, they don't have to add NA or no. It's just they can leave it blank. That's just to clarifying that. Based on that proposed validation, they don't have to put anything on novation if there is no novation. They can leave it blank. Based on
Why
this.
is there a no? Then why is there a no? Why shouldn't it only be yes? That having the no would make everyone think they have to fill it out.
Yeah, sure. That's a good point. You can just make it yes or leave it blank. But
again, I think it's, I don't understand the need to, if an ovation means, the new CID entity starting over from scratch.
Yes, the reason we are proposing that, because the contract is just disappear from the system, and we don't have any any way to track it. Why is it just by accident? Is not, they didn't report it, the filers didn't report it, or is it just terminated?
Well, they would terminate. They'd have the seller has to report the actual termination. When you novate a contract, you actually terminate it. So the seller has to report an actual termination, and the new seller, if they're jurisdictional, is going to have to report a contract. So all the information is being reported. The only thing not being reported is the linkage, but you would definitely have to report the termination of a contract. If you're, if you're the seller and it's being novated, you've terminated all your obligations. So you would report an actual termination date.
Really, Jennifer, am I unmuted still?
Yeah.
Okay, because then maybe I did not think you needed to put in a termination date because the contract didn't terminate, it was novated. And maybe there's a legal distinction between assignment and termination that I'm missing. And I have the feeling on this discussion of novation, they might have meant to include assignment, but so that's interesting.
Yeah,
I thought the contract goes on, it's just with different counterparties, and the person that the utility that contract was novated to, I would think, would use the original execution.
I'm talking from the seller perspective
and report it. So,
well, Barbara, I was talking about from the seller perspective. Sorry, I'm talking over Barbara. I'm sorry, Barbara. I'm talking about from the seller, because they're talking about novated as sold as transferred to a party with, well, I'm talking about the seller with the CID, because the buyer might not even have a CID. If the seller novates, the seller, that contract is terminated as to that seller. And what I'm saying is, if it's the buyer that changes, it's almost always an assignment. It's almost unheard of to do an novation when the buyer changes, because most contracts allow for assignment, which is a lot easier and simpler than novation. Because like I said, novation is a whole legal thing where, it's different. And I think people would get extremely confused. That's why I'm saying people would get extremely confused. But clearly, if you're the seller, if you're novating to a new seller, you need to terminate your old contract, because that contract doesn't exist as to you as a seller.
So I have not guided my clients previously. I've said if it's, and if it's novated, and I may be using the term, maybe in all these cases it was assigned, but I would just say stop reporting it. I usually say add a note in the extension provision field, so it just doesn't disappear from your EQR. So if someone is looking at your EQR next, they can figure that out because you've put that information in. But I guess at the very least, we need clear guidance, even on the first, in the current scenario of how those things should be reported.
Jennifer, am I unmuted? This is Rhonda. Yeah. I got a question. So if a seller is novating a contract, but what about certain transactions maybe they are not novating to the buyer. So how does that work as far as if they're novating the contract except for maybe certain transactions under that contract, and those transactions continue for, I don't know, maybe a year or more, how does that work?
Well, I was speaking of novation in terms of the seller. The seller is no longer the seller. So if the seller has a contract under which it can make sales to various, it can make various sales, if it's no longer going to be the seller, it's going to no longer have those transactions. The new company, the company who's taking over the contract as the seller would have responsibility for all those contracts underneath. You know, if there's an umbrella agreement, if ABC company has an umbrella agreement and has 3 transactions, if ABC company is not going to be the seller and DEF company is going to be the seller, ABC isn't going to have a contract anymore. ABC isn't going to sell to those, continue those 3 transactions. Are going to be taken over by the new seller. The new seller is going to be reporting all those.
Yeah, I agree with Jennifer. I've never seen a scenario.
The seller has nothing to do anymore. If the seller is not going to be the seller anymore, the seller has absolutely nothing to do with the contract anymore.
Okay.
Or the transactions under it.
Or the transactions under it.
Okay, because I was thinking that there had been some kind of back in the past where they may have novated the contract and maybe a limited number of transactions under that contract for whatever reason, and those were continued.
Well, then they'd need a contract. How could they report transactions on EQR without a contract? They'd have to tie those transactions to a brand new contract. They need a new umbrella service agreement to put those contracts under, or they couldn't report those transactions.
Gotcha.
Okay. Yeah, I've seen cases an ISDA with power annex, and there are existing transactions under the EEI, and they say they're going to terminate the EEI like at the end of those transactions, and they open up an ISDA with power annex, and in that case, you would go to you would report both until the transactions flow. But I've never seen it where you've novated it to a different counterparty. If you novate it, that's the whole point. Those transactions end.
Okay.
Or are transferred.
Okay, great. I don't have any questions in the Q&A, and everybody who had raised their hand has been unmuted. I don't know if there were more things to talk about, Rhonda and Renee, or if you were just adding to those things. That's great. Feel free to lower your hands and we can move on or chime back in.
Rob, this is Maria. May I ask a quick question to either, well, Jennifer or Barbara, if you're still unmuted. So to the extent that there is an assignment, let's say, let's set aside novations, but if there is an assignment to a new counterparty, to a new buyer, then would it typically be the case that the contract is terminated or that it just continues but with the new buyer?
Yeah, usually field 17 would be changed and that's it.
And that's it. So
Right.
the contract would continue basically.
Yep.
It's just that the counterparty name, the name of the customer company would change.
Exactly.
Yep.
Okay, thank you.
Mrs. Renee, I agree with that. I also have a question. I thought the whole point of being able to remove a contract was once the actual termination date was populated, then it can be removed the next quarter out. So I'm afraid like combining fields would cause confusion on that. And then I also have like a situation where it's a very old contract, but there was a termination date in the contract, but it was also evergreen. That contract's not been changed or amended. So I have a termination date of years ago that's still active. So that in some of your situations, that would be flagged, especially if we got rid of one of those fields. So those are my thoughts on these fields.
Yeah, so this is Sohila. So are you suggesting that, like, if the contract is evergreen, then they have some termination date?
It's usually extended. Like Barbara mentioned, I believe that it will continue on until notice is given that it's terminating. And it's still active, like very much active.
So Renee, can I just have a follow-up question? In that scenario, then you would where you have this contract that under its terms it terminated some time ago. So you would put under the contract termination date that date, but you would not have that actual termination date until whenever notice is provided and the contract actually terminates. Did I understand that correctly? Okay.
Correct.
So you would advise that we keep both fields because of a situation like the one that you're describing?
It kind of goes to what Barbara was saying about, you know, if you're continuing services under an agreement because you just don't have one yet, but you had an actual termination, not actual, sorry, you had a termination date listed on the contract, per FERC, we're supposed to populate that. And you don't make changes until the contract's actually changed. Well, the contract's never changed. So it's still evergreen with that extension provision of once it's going to be terminated, you have so much time to do so.
Right. Thank you.
And
Another thing I wanted to say.
I just wanted to agree that that's a fairly common occurrence that a contract has an actual termination date, but it doesn't actually terminate because nobody, FERC is clear that an agreement that's been filed at FERC can't be terminated without a filing at FERC. So it's not infrequent
Also,
that contracts go on.
The actual termination date is sort of a legal way that you terminate your contract at FERC prior to the EQR. Any contract that was terminated, the utility had to actually file paper to terminate that contract. So the actual termination date was supposed to make everything easier, that you wouldn't have to make a filing. You would put the actual termination date in, and that was sort of the official. So it was a more specific definition than the contract termination date.
And one more behind the scene comment that I have is using that actual termination date. And I haven't done a manual EQR in a very long time, but the whole copy forward function and ignoring contracts that terminate so that they're automatically removed. I don't think making one field with a date in it would work. You know, the user would then have to pay attention to what that date is and whether or not the contract can be removed going forward versus being automated. Does that make sense?
Yes, thank you.
Okay.
All right, I think we're out of comments. Jennifer, your hand is still raised. If you have another comment, I think you can unmute yourself or oh, there you go. So I think that may be it. So Hala, is there anything more or any more questions from FERC staff to attendees? Renee, if you had something more to add, go ahead. You're still unmuted.
I just wanted to add on the novation conversation. For as many companies as I file, I can't say I've ever had a novation in all of these years. It was already mentioned that it was rare in some degrees, but we're mainly power, not transmission. So.
Okay, thanks. Yeah, so if there is no any other questions or comments, I think it's time for lunch break.
Yeah, let's do a lunch break.
We will have 1 hour for lunch break. It's almost 12:25. Let's come back at 1:35.
1:35. Okay.
I'm sorry, 1:25.
Let's just make it an easy 1:30. So that way, yeah.
Okay. All right.
Thanks, everybody. We'll see you back here at 1:30.
I just wanted to let you guys know I can hear that someone's unmuted. Just double check yourselves, make sure your mics are muted. Thank you.
And I can't figure out how to mute it, if it is.
Yeah, I can hear you.
I can hear you too.
So how do I thought you guys had to unmute it at your end. I guess I can just do it on my PC, but so.
Hey, Marina or Sohaila, can you guys do a mute all?
Sure, let me find that function.
I think I'm muted now, so let me know if you can hear me.
Yeah, we can hear you.
Oh, shoot. I even pushed the little button on my PC, so. How about now? Can you hear me?
Yes.
Yes,
Well,
we
damn.
can hear you.
What good's the little bar with the microphone? Good thing I wasn't saying rude things. How can I can't, on the screen, I can't do it. You know, it shows like a silhouette microphone next to my name. That looks exactly like yours that are muted. Except I see Marina, you're not, and Sohaila's not, but I don't know how to.
Yeah,
Hey,
let's
Marina,
see.
this is Renee. What key do you have the mute button on? Is it your F4 key?
F4, yeah.
Do you use your F functions? Like when you hit F4, does it usually do an F4
Just,
function?
I mean, I did that, and usually that works, and it didn't.
Hit your function key and the F4 key, and that may activate it.
Okay, I just tried that. I'm going to try it now. Can you still hear me?
Yep.
Yes.
Okay, that's,
you.
yeah, because I just tried that before, and that usually works, and I'm not sure why. I mean, I can just get out of the whole app, but I'm not sure. I mean, I think before I was muted at times, but I'm not sure.
Yeah.
And I
Marina,
have a little
I think
icon with the,
because Rob is the host, he can mute everybody if we can ask Rob.
oh,
I just sent Rob a note to see if he could mute all. But Barbara, down at the bottom of the WebEx screen, do you see did you have a little mute button or a little microphone button? When you press it, does it turn red for you?
well, actually, it says now I'm on mute, and when I press it and it turns red, okay, it does turn red, so I think if
We can. Okay. So I don't hear anything anymore, Barbara. If you are
Yeah,
saying something.
I don't either.
okay, I
I
just
think
unmuted myself
maybe
for a
that works.
second, so
I'm gonna
that
go on mute
works.
also.
Okay, so I'm putting it back on. You know, it showed the microphone with a slash across it, so I thought that meant I was muted, but I have to click on it to turn it red, and that makes it muted. So, okay.
Yeah, once it turns red, then you should be muted.
Okay, sounds good. Thanks.
Great.
Bye.
Thanks.
Thank you.
Hi, everybody. This is Rob Hudson again. We'll get started here in just a minute. I wanted to go through again the logistics of the conference that was on the, I think, second slide. Instead of us, trying to page back through it, I'm just going to go over the little notes here again. So everybody is usually on mute right now until, just to make things easier. Only I'll be able to unmute people, so you'll have to get my attention. And the way to do that when you want to chat and participate during the discussions, and we encourage everyone to do so, is to raise your hand. So just click the hand icon to raise your hand. It depends on if you're on it's in different places on the screen. So I apologize, I don't know where it would be on your specific version, but that'll raise your hand and get my attention that you want to be unmuted. And we'll have a conversation about unmuting you and things like that. The chat box is on. And it's just for more discussion if you want to have it in the background among the participants to the call. FERC staff isn't responding to any questions put into the text box, but we are looking at it and using it if it's necessary. If you have a specific question, please put it in the Q&A box. Questions here are reviewed by all FERC staff and will either raise it in during while we're talking or while we're or we'll respond to you with text. This is being recorded. It'll be made available on the FERC.gov website. You'll be able to watch it again. As Jeff noted earlier, we are not providing a transcript for this session. And questions, as usual, can be emailed to eqr@ferc.gov, but we won't be monitoring those emailed questions during today's call, but we will get to them afterwards. With that, we'll get back to Sohaila. Go ahead, Sohaila.
Thanks, Rob. Good afternoon, everyone. Welcome back. And again, my name is Sohaila Mansouri, and I'm continue our presentation by continuing discussing the product name, Other. And on today's presentation on product name, we will be narrowing focus on the option Other. And we'll return to discuss the remaining 33 options for this field at the future tech conference. What we propose to do is to modify how Other is defined. The reason we are considering this is we are seeing that Other has been serving as a catch-all category for product name, and it's the fourth most used product from the list of 33 options. This category is so broad that it captures dozens of freehand text entries each quarter, which makes it difficult to do any analysis on the data. The current definition for Other is a product name not otherwise included. We propose to modify the definition as shown on this slide. Product name not otherwise listed in Appendix A of the EQR Data Dictionary. If product name Other is used, a product name description is required, describing the product sold. The product name description is a new field we propose to add to, which is the unlimited characters, so that it allows a place to provide an explanation for whatever is put on Other. A validation would make this field required if a field selected, if a filer selected Other on this field. Staff reviewed the most commonly used terms when filers use Other under product name. Specifically, we reviewed the rate description field and found these three categories are the most commonly typed in. We therefore propose to add these three terms as options under product name. And hopefully this would offer filers a more current list that matches their reporting needs and reduce the reliance on the catch-all category Other. In the next few slides, I'll discuss each of these new product name in greater detail. The first new product name we propose to offer in Appendix A is the term bundled. The proposed definition for bundled would be services provided for bundled transmission, ancillary services, renewable energy certification, and/or energy. If bundled is selected, then identify the service being provided in product name description, which is a new field. We'll talk about the new product name description field in the next slide. For transparency, what we'd like to see is a breakdown of what products are being bundled. So filers would have the option to select bundled in contract field 31 and transaction field 63. Then they would be required to select at least 2 product names. To make this possible, we propose to create new field in the contract section where if bundled is selected, then all the bundled products from Appendix A should be listed, delimited by comma or semicolon in the new field. This information would only need to be entered once under the contract section, and it wouldn't be required under transactions since we already be collecting the information. The new option bundled would have 2 new validations. The first validation would require that if a filer enters bundle in field 31 contract, then they must also select bundled in field 63 transaction section. This would be required, otherwise the system will reject the filing attempt. The second is that whatever products are being bundled, they must come from the list in Appendix A. It's not going to be a free-for-all combination of bundled products. So filers cannot go outside the list provided in Appendix A. So during our 5th discussion, I'd like participants to share their thoughts on the following. Would adding bundle to Appendix A be helpful? Is staff's proposed definition clear and accurate? What is captured when filers report bundled in the rate description field to accompany the field 31 other?
Okay, everybody, we'll jump right into the discussion as we've done in the past. I see a couple of hands up, and we have a question. I have a couple of hands up. So we'll start with Jennifer. Jennifer, you're unmuted. Go ahead.
Okay, I have probably a lot of questions, but I'll start with some basics and then let some other people go. The first question I have is the definition seems very odd in that capacity is not included, because energy and capacity are very commonly bundled together in contracts. So I just didn't understand, and I'm putting aside the common use. I want to start with saying bundled is used in the industry in a very different way than you all are proposing, but the first, I just didn't understand why capacity was missing from the definition of bundled, since that seemed to be sort of the major, a major product that was missing. So that was question 1, and maybe if we could just get an answer to that, was that just an oversight, or is there some reason that capacity is not in there?
Hey, Jennifer, this is Maria. I think that was an oversight. I don't think that was meant to be necessarily excluded.
Okay. I guess then my second question is this, to sort of understand what you're trying to do. I mean, obviously today, you know, there's lots of contracts that have multiple products, and I'm assuming if a contract has multiple products with a price for each, such as a NHTSA today, which would have, you know, every NHTSA should have 7 products, putting aside ISOs, you know, an old fashioned NHTSA, you're going to have network service and 6 ancillary services in the NHTSA contract. You might have an 8th product if you have wholesale distribution service, which might be, you know, put in as an other, which you hate. But am I right? Is the notion here is that you're looking for services where there's multiple products but one rate, such that, you know, a contract where the energy and capacity price is bundled together? Or, for example, some non-jurisdictional entities in particular would bundle transmission ancillary services, energy and capacity, and charge one single rate because they're still allowed to. You know, obviously investor-owned utilities, that would probably be a grandfathered requirements contract because they're not allowed to bundle transmission anymore, or really ancillary services. So, but just from an overview is, you know, I'm assuming you don't want the NHTSAs that are there now to go from like 7 products or 8 products down to one bundled, or maybe you do, and, you know, but that doesn't seem right. But is the notion always that there's going to be one price for the bundled product? Because it doesn't, that would seem to make sense, as the reason you're doing this is to, you know, is where there's only one price, but there's several services being sold at that one price, such as energy and RECs or energy capacity and RECs are being combined with one price. So
yeah, this is Sohela. Yeah, I think that's the reason that we want to add that bundle, because that's how the filers are reporting it. It is one price, but we don't know what are on the bundle, what was included on that, even if they cannot have, it's not different price. That's why we ask to just only the new field to list the products in the bundle only on the contract section, not in the transaction section.
Because I think if that's the idea, I think the definition, certainly, I mean, I won't get into yet. I want to hear from other people about their ideas. I think it really, the definition should focus on multiple services, multiple jurisdictional services provided at a single bundled price, you know, with the product, you know, all of each of the bundled products, you know, needs to be, you know, talk about the identification. But I think the whole thing is very confusing unless you get the notion of this is a case where there's one price for a whole bunch of different products. And that's not coming across at all in the definition. But if any other people have any other ideas about what bundled should be, you know, I want to listen to them. But if that's what bundled is meant for, to capture those multiple product, you know, at a single price, it would make much more to focus on the price and not to list the products, because, you know, there's whatever many product names do you have, you know, you have 50, 60 different products that could theoretically be bundled, not all together, but, you know, if you have 50 different products, listing 4 or 5 of them doesn't seem to make a lot of sense to me. But with that, I'm going to turn it over to others to make sure that others have a common understanding of what bundled might be used for. I know Barb wants to talk.
Yeah, sorry about that. I had a little bit of a glitch there.
Okay.
Let me go ahead and put, and I'm going to unmute Barbara, and she can talk. And we have a couple of points that have come into Q&A that I'll review. Barbara, go ahead and I'll review these and jump in if
Yes,
they're.
you were right,
if they
Jennifer.
have-
I
Yeah.
did. I don't disagree with anything Jennifer said, but I do come at it from a little bit different perspective. And I think that might be a little closer to what you guys were thinking of, because I report for probably over 50 renewable utilities. And so frequently in a solar or a wind contract, they have one rolled in rate for and capacity and this and that and whatever, and we own all the rights to the contract. So, and I know there are just a boatload of others who are reporting those kind of contracts. So what I get concerned about with the definition of talking about bundling transmission and ancillary services and RECs and whatever, that it may be too broad and confusing. One of the questions I had was, go away and another concern I had was when you say that you have to identify all of the products that you're selling, in many of the contracts, particularly the more recent renewable contracts, they so don't know what it is when they're writing the contract, what all these products are, that they have now frequently, I see language saying basically, and basically what the purchaser is saying is we own the rights to everything that comes out of that plant or gets paid for from that plant. An example might be where there were a lot of wind contracts, say in PJM, and contracts were written for, everything as they saw it. That was energy, capacity, this, that, and the other thing. But then later on, PJM is paying for reactive power from those plants. So the plants are able to get a tariff and sell reactive power to PJM, and it doesn't go to the purchaser of the energy. And so I think that some of the purchasers are now expanding the, so-called theory of bundled to include anything, and anything's not an option on the EQR. It gets us back to other. And so sometimes you don't know what those things are when you're reading the contract, and it may be 5 years into, hey, there's money to be made here, we're going to make it. And so I think that's a concern. One other concern, you talked about having no maximum characters, I think, in the description for the other product name. And just, I think you've also stated in the past that extension provision has no maximum characters, but it actually does.
Yeah.
Would be a little concerned about saying there's no maximum character. You may want a large maximum, but I would not leave something open-ended like that, just from a technical standpoint. Having broken the system last time with your extension provision, so.
Yeah.
Yeah, the characters, it wouldn't be a problem in XBRL.
Okay.
The length of the character field or things like that. So that's why that's in there. Go ahead, Sohaila. I'm sorry to cut you off.
Yeah, no, that was what I was going to say. Yeah, with XBRL, we don't have any problem with the limitation of the character. The other
But
thing
what about
is,
the database that you're putting it into? The database has to have.
database can handle it. Database can
Okay.
handle it also.
Okay.
Yes. Yes, but the other thing is you mentioned, still we will have other in the option for the Appendix A. We just want to eliminate using too much of other for if you think bundled is gonna eliminate using of other. That's why we are suggesting to have bundle, added the bundle, another option, but still other is gonna be one option on the Appendix A.
Hey,
And
Barbara, this is Jeff Sanders. I have one follow-up question.
Sure.
Were you going to respond to Sohaila first?
No, no, go ahead with your question.
I was curious when you said that some of the renewables contracts are written without knowing what the products are, and it's not necessarily clear at the time of writing the contract, and sometimes it's only for after a significant amount of time has passed. What portion of the contracts that have you seen that have those? Is this a common thing, or like if you were to put just a general ballpark on whether it's how many you see or percentage or how common that might be?
Historically, it wasn't common. In the more recent renewable contracts that I've been looking at, I've seen much broader language when in the contract they're talking about what it covers. And it may vary from contract to contract in how they state it, but how I infer what they're writing is, hey, we own everything that comes out of this plant. And so no matter what you call it. And so sometimes they're talking about the RECs, and then they always throw in language or of, whatever.
Yeah.
I think changes if there's renewable energy credits of any type. And so, and the same thing with the other products. And my guess is some of that got started because of the situation with reactive power, but I may be wrong. That was just sort of my impression that they realized, hey, we don't know what we don't know, and we don't know, particularly when selling to an ISO, what the ISOs are going to pay for in the future. So we're going to just leave, as a purchaser, we want to make sure whatever money's being gotten from the output of this plant, since we're paying for the energy and all the related products, we want to make sure it covers everything. But so it's more the last like year or two that I've seen that.
Okay.
Yeah, I agree with Barbara, because there's been a lot of litigation over generators seeking payment for reactive, and the buyer saying, no, you already sold it to us and you can't get paid for it twice.
Okay. All
So
right.
I think there would be a lot a renewable bundled kind of thing that was, say, energy capacity, renewable energy credits, and other products paid for from a renewable energy plant. I would guess that there would be at least 200 EQRs that would fit into that description. And that's at the very least, because I know how many I file, and I know how many other companies have that, are for renewable entities, and the vast majority of them have it bundled. I think less than 5% pull out the REC price separately. Although there's been some changes in California that the separation of the REC price is I've seen that more in the last 6 to 9 months. But I think there would be a lot. And then question of, well, does grandfather bundle go away? And that was supposed to be where transmission and power, and that should be a dying thing because you can't do that anymore. But so it was just old contracts, which is why the grandfather was in there. And the other kind of bundled is requirement service. And there's already a product for that, a product name for that.
Yeah, so
Yeah, Barbara, sorry, it's Jennifer. As one thing, Barbara, to remember is with the large non-jurisdictionals, there could be a non-jurisdictional bundled product where they are allowed to bundle their transmission with their energy and capacity. But if you kept the grandfathered, meaning it would be like IOU, it would be FERC jurisdictional grandfathered or non-jurisdictional bundled, because whereas the FERC jurisdictional entities, which can be cooperatives, of course, need to be, the FERC jurisdictionals have grandfathered, bundled, but non-jurisdictionals that do have to report can have current bundled.
Yeah, just this is Sohaila, just to let you know that on next slide we are discussing that grandfather bundle, and we don't say
Okay.
that's going to go away, but yeah, this is going to be extra the bundle. Yes.
Being bundled is in some of the retail supply contracts in the Mid-Atlantic and on the East Coast. They have started throwing, so they bundled ancillary services in. There's a fee, it's usually around $2 in the contracts when they've gotten them, that they're paid $2 per megawatt hour for ancillary services. It doesn't specify what ancillary services, it's just in there, and the so they can serve their customers, they charge that. And you know, I've always been told if it's on the invoice, put it on the EQR. So that is something else that would be reported by other, that it's bundled, but based on how the contract's written, you don't know what ancillary services that covers. It's not defined in the contract.
Okay, I'm going to jump in here with a couple of comments that I've put into the Q&A. So it's just some questions and comments, and see if some FERC staff wants to take them. So Sherry Para asks, if you are currently reporting energy sales that included bundled RECs, would you now be required to note that as a bundled service and note RECs in the product name description? She also goes on to say the energy price would be separate as well as market in some cases for the RECs, and it would be very difficult to differentiate. Is Maria or Sohaila or Marina, do you have any response to this, or are we just going to take this back as a note?
Hey Rob, this is Maria. Can we maybe save that for the discussion of the REC? Coming later, just so we can discuss it in the context of that.
We'll discuss this in the context of the REC. So Sherry, just bear with us. We'll get to RECs in a little bit. Yeah, David Lowe also asked another question about RECs. I'll read it here and we'll probably save it. Is the intent of adding RECs only to be used when RECs are bundled, not to report sales of RECs on standalone basis? And then we talk more about bundled things. I've seen contracts with energy and RECs bundled. This is from Joan Smith. Since RECs are not a product, we would still use other. Does that meet FERC's need? And then Sheila added one more. Sheila Pakulski added, I have a question on other. What is the thought if the description is for several things? So I think that's more about other.
Yeah. Can you explain on that?
Hey Sheila, do you if you have a mic, I can unmute you pretty quickly if that's okay. You want to just raise your hand? Can't find your hand. That's okay. I will unmute you right now anyway. Go ahead, Sheila.
Can you hear me?
We can. Yes.
Okay, excellent. So the question is so like in the contracts you put other, but for certain contracts I might be using other for several different types of things depending on what I'm using that for. So I was just trying to understand what the thought process, like, are we going to put several different other fields now, or?
Yeah, so if you choose other on field 31, that is the contract, then we are suggesting to add the new field that you can list whatever is, if you choose bundled for field 31, then we can we add a new field that you can describe what are on that bundled. You're talking about just other or bundled?
Well, either of them. So my question is like, so say I'm using other because for one description is that for some of the California charges, it's really a capacity charge, but the way FERC doesn't allow capacity to be done at the level it's doing it. So we report it as an other. But in other cases, it could be, I can't think of my other one right now. But it's not a capacity, but it doesn't fall into the other categories. So my question becomes is, do you end up with two different other lines at that point? So I have other with one description and other with another description, or do I put other and then try to list all my possible, what I'm using it for? That makes sense?
Yeah, you choose other, and then on that new field, you can add whatever you think is on that other, all the possible, like the products that are on that list. You can list it on one field, but separate them with comma or semicolon on that new field.
Okay. So I guess my
Instead of
only,
the product.
okay, so I guess my only feedback on that would be is that while I might list, hey, I'm doing other, and it's really, it could be because I'm doing X, Y, and Z, and it just didn't fall into these, or I'm trying to report some kind of charge code and ISO is doing, and it just didn't fall into these categories. But on my transactions, it could fall into one of those or both of those, or so. I guess I'm trying to figure out what that's really, if that's just going to cause a little bit of confusion, because what I might be using other for could vary by transaction.
So you can, if you
multiple other products, particularly if the rates for those different products were different, you would need multiple lines of other.
Well, for
on the transaction, not on the contract, right? If you
No, on the contract, if you had, say you had a startup charge for a generator and you also had a pass through of something, and you had prices in the contract, if it was a PPA with rates detailed, you would need to describe each of those things. And so the guidance I've received in previous years has been, if you had multiple products that qualified as other, you should repeat that.
Yes, if the price is different, right? If you cannot. Mhm.
Barbara, you are correct. This is Roxana. Yes, other can, you can have in a contract, and therefore in a transaction other, because by definition, other means everything other than what we have in Appendix A. So if you have other startup cost, you would have one other. And if you have other, maybe O&M expense, you would have a second other. You are correct.
I think maybe the asker's question may relate to, let's say you have two others and they're both, energy related, so they have to be reported in transactions. So you might have an other that is, I don't know, startup cost, we'll just make something up, one other is startup cost and one other is, CAISO charge, CAISO blank, CAISO charge type 5 is when you report the transactions, you'd have to report both of the others, but you both would relate back to the contract that had two others, but you really wouldn't know which charge was for maybe for which other product. Does that make sense?
Yeah. So our goal, like if we go to the, basics of why we do this, our goal is to make sure that we don't get in this situation. We have a ton of others for different products that we don't have in the product A. So our goal is to make it easier and simpler for you and for us to understand what that other is. Because again, if we end up in a contract with 5 lines of other representing different things, wouldn't be easier and better for everyone to, instead of having other, to have a product that better represents what that product would be. So that's the goal of what we're doing, all this, to offer clarification and simplicity in reporting, instead of having, I'm exaggerating, maybe 15 others for different things.
Okay, I'm gonna go through a couple more of the questions here and see. So we're going to get to Rex next. And there's a lot of question about Rex. Is there anything more specific to that's not specific to Rex that falls under this category? If there's anyone that wants to speak up, Barbara, you still have your hand raised, but that's okay. I think you're good. If not, then come back in. I think you can mute and unmute. And I think we're pretty good on this, right? So Hala, do you want to move on?
Yeah, if there is no other comments or questions.
A lot of questions about Rex, but I know that you're going to cover those.
Yeah,
so.
we're going to cover that. Yeah.
Yeah.
Okay. Let's first cover the grandfather bundle. So we've been discussing some proposed option for reporting bundled contracts, and this slide should focus on two terms that are related to the bundle concept and are currently offered as product name in Appendix A. We would like to hear from you about requirement service and grandfather bundle. We're trying to add another layer of understanding and transparency what is being sold under requirement service contracts and under grandfather bundle. Based on the data dictionary, FERC staff considers that grandfather bundle captures two or more of the three products: transmission, ancillary services, and energy under contracts effective prior to order number 888. We would like to know, are filers interpreting the grandfather bundle definition as the same as staff? And what are the challenges filers face if reporting more than one product at the same time with an all-in price under product name in contract, field 31 or transaction field 63? What products are captured when filers report requirement service in field 31? Are there any examples from filers where requirement service isn't bundled with more than one product? And for requirement service, do filers consider load following to be a requirement for this term as defined in the data dictionary? Any comments?
We'll wait for some comments to come in. Barbara, I'm going to unmute you now and love to hear. Oh, you're unmuted. Perfect. Go for it, Barbara.
For requirement service, I do consider it to be load following to be requirement service. But I do think there may be examples where requirement service isn't specifically bundled with more than one product. I think some of the retail supply contracts just they supply energy. Now it may be capacity, so it may be bundled in a way, even though that's not explicitly stated yet. And then I'm sort of doing these questions in reverse order. What products are captured when filers report requirement service? Most of it is energy capacity. Sometimes there's an ancillary services fee, and there may be a transmission add-on, but usually that's captured in the total transmission charge. In the next to last field in the transaction data. And so maybe that will help. And I am interpreting grandfathered bundled the way you state in the first bullet.
Yeah, thank you.
Barbara, this is Don Callow.
Hey, Don.
Sorry. Yeah. So the question I have I thought I heard you say you could have, for grandfathered bundle, say transmission, and does it require all three products in your mind, or could it be two of those three? Does it always have to include transmission, ancillary, and energy, or could it be ancillary and energy? That sometimes I'm asking that of you, but I'm wondering of other people on the thing. Do people report it with less than all three products?
Yeah, this is Jennifer. You could have, an old grandfathered point-to-point agreement, which would only have transmission and ancillary services. So if you had pre-oat transmission, you could have just transmission and ancillary services. And I don't
But
know if you
Jen, wouldn't that be?
under point-to-point. I guess you could put that under point-to-point and not mention the ancillary services because it would all be one price, but in reality, it does include the ancillary services. So really, but
I will tell you, back in the day when we were setting this up, what our intention was this is when energy and transmission were sold together.
Okay.
So I think
That
by
makes sense
definition, or at least I think by definition, at least it has to include transmission. But this was a way to capture rates that were in those contracts where there was a power sale in addition to the transmission, and you couldn't separate them.
Yep.
Yeah. No, that makes sense.
Were written. There wasn't really such a thing as the separate ancillary services. I think in a large part you just kind of got that as part. It probably did include all of that, but it might not have been even mentioned in those contracts.
Yeah.
Okay, thank you.
Okay, any more comments on grandfathered, bundled, and requirement services? Looking through the chat, hasn't been any Q&A questions submitted. So if there's anybody who wants to discuss grandfathered, bundled, and requirement services, please do so. I'm going to go ahead and make the questions on Rex because it's going to come up after the break public, so everybody can see them. Hopefully and we'll get to them. I'm just going to mark them as answered verbally, but we will get to them in the next session. So during the break, you can think about these and the upcoming slides to talk about Rex.
Okay. If there is, oh, sorry.
No, I think it's time for, is it time for a 10-minute break, or do you want to steam on through? I have a feeling that Rex is going to be a long conversation. But I think we're scheduled for a 10-minute break. Isn't that right, Marina, by the agenda?
I think we were going to take that break after Rex.
After
but
Rex.
But if we can have it, we can change the order. We can have a break first.
It's up to you, Sohaila. I think that there'll be a lot to discuss on Rex.
Yeah, that sounds like a good idea.
Yeah. Okay. For 10 minutes break is almost 2:15. So we'll be back on 2:25.
Okay.
That's good.
That sounds great.
Yeah.
Okay. Thanks.
Welcome back, everybody. So hey, let's go ahead and get started when you have it, when you are able to.
Okay. Yeah, thanks. Okay, that's what we all waiting for, REC. So REC is another category that is often reported by filers in other. We would like to understand why filers choose REC as a category for other as product name. Besides all of those questions that you have, we also would like to discuss the question for this session as shows in this slide. Are filers able to separate out the REC portion of the price from the energy portion of a sale? What are your thoughts on staff's proposal to add REC to Appendix A? So, Rob, if you want to read those questions again that we had.
Yeah, let's go back through these. A little while. First questions on RECs was from Sherry. If you are currently reporting energy sales that included bundled RECs, would you now be required to note that as a bundled service and note RECs in the product name description? She went on to comment, the energy price would be separate as well as market in some cases for the RECs, and it would be very difficult to differentiate.
Okay. I'm not sure if Maria or Roxana have any other thoughts on that.
All right, well, we'll just take that question back.
So could I ask a clarifying question with respect to Sherry's question? So Sherry, you're saying you're currently reporting it, or anticipating a scenario where you would have bundled RECs, and I think what, judging from your question, I think what you're saying is that the energy price is separate, but it would be difficult to identify it separately and report it separately. Is that what you were saying from your your question.
Sherry, I could unmute you if you'd like. If you wanted to raise your hand and we could have a discussion about your question. Oh, okay, that's okay. I can unmute you on your own. Sherry, you're unmuted. Go ahead.
Okay, thank you. I'm sorry about that. I couldn't find my hand.
That's okay. It just took me a while to scroll through to find your name.
Yeah, and I, may not be understanding the purpose here, but my point is yes, we are selling energy in two markets, and we qualify for RECs due to those energy sales, but the RECs are bundled, so we don't report them separately. We also don't know, when those RECs are going to be issued or sold, or the price contract, but it's not always collaborative, I guess maybe is the word. So I just wondered if now we're reporting energy sales, do we now need to note those as this is an energy sale, but it is a bundled sale and there are renewable credits associated with it, but yet you're not going to have that renewable energy credit information like price or amount.
Right. So the price of the REC may not be determined until a later time. Is that what you're saying? So you may not know the price in advance, even though that product is bundled with the energy sale.
Correct. Or the counterparty or anything.
Right. Right. And I
you may, but you may not.
Right. Right. And I mean, I think that is a situation we would have to think about. I think it would be or one of the major sort of one of the major benefits that I would see, at least to identifying that there is a REC there, even if there isn't necessarily a separate price associated, is that it would give us a little bit more insight into, that there's a REC being sold along with the energy.
Yeah.
So you may not be able to. It sounds like you as to question 1, for example, on this slide, it sounds like maybe you would have trouble separating that out at the time of the energy sale, the price for the
right, and that's correct. And just noting it that this is an energy sale would be fine, because these are wind farms, so renewable credits are there, but you also don't even know what your the megawatts that are going to convert to RECs.
Right.
The 1-to-1, but they may not accept that 1-to-1 in the other market. So you don't know that it's going, that each megawatt is going to be one REC.
Right. So you don't know the quantity necessarily or the price necessarily at the time of the energy sale. Okay.
Right. You just know that it qualifies, and you also don't know whether you sell it in, New York ISO or ISO New England. So I'm not how much information I'll give to you. Just kind of knowing that, oh, this is a wind farm. There's gonna be RECs. It's just kind of noting it in the field, I guess.
So this is Roxana. I just want to clarify because we sale means different things to different people. For us, sale means contract and transaction. So I just want to clarify that all the information is unknown at the time of the contract. I just want to clarify that when you when actually the power flow happens and you actually sell energy, is it the same situation where you don't know the quantity, the price, and everything else, so they're still unknown at the time of the flow, or are those unknown? Those unknowns are limited only to the contract time.
I think the unknowns are related to the energy flow. I mean, we're constantly selling to counterparties, right? And it's different amounts, it's different prices, it's different time periods. They may want RECs from 2024, or the current energy flow, it may have been sold 2 years prior. And if you you sell everything in one market, you may have some left over. Well, you could sell that in this market, you know, in real time or in a contract. You just don't know.
This is Barb. Can I jump in? Because it sounds like the RECs that she's talking about selling are not bundled with the energy she's selling, in which case they're not even FERC jurisdictional and don't need to be reported.
That may be absolutely correct, Barb.
Yeah.
Because this is Jennifer, and I wanted to sort of ask almost the opposite question. Is my understanding of this proposal is if you're selling bundled energy and RECs and maybe capacities in there too, if you're selling bundled with a known price and you're never going to be able to unbundle the REC price, the right way to report it now, instead of reporting an energy sale, would be to report a bundled sale, and the products would be energy, RECs, and if you were selling capacity too, it would be capacity. So you would, the correct way.
Well, to report
under
it
this
that
new
way now,
system-
there is no such thing as a bundled.
Right, no, but under the new,
No.
if they created the new bundled.
Oh, okay.
That's not any energy and REC that was bundled where you can't unbundle would then, those would now go under bundled instead of under energy. Is that correct?
That is correct. Yes.
That's what I understood.
Yes.
And Barbara,
that
I
is
just
going to be to the new system. Not currently. There is no way.
Because if you can separate the price, if you're able to separate the price, you should be reporting an energy sale and a REC sale separately.
If they're being sold to the same counterparty.
Right, if you're going to the same counterparty under the same contract.
Yes. So if they're separate, if there's a separate contract for the RECs versus the energy, then you don't report the RECs.
Then you don't report the RECs at all. That's
right. So I just want to clarify that all the discussion that we have about the RECs, to respond to Barbara's question, are only and only about the RECs. They are sold in connection with the energy and are jurisdictional. We are not collecting and we're not talking about RECs that are sold independent of energy and not jurisdictional. Just wanted to make sure that we have the kind of foundation clarified.
And I think the answer to your first question. Go ahead, Jennifer.
I think to that, I think the name of the product should be jurisdictional RECs, or otherwise you're going to get, if you're going to put out a rulemaking or whatever, I would rename the product for jurisdictional RECs.
Or something, at least, or the definition in the product name, maybe in say RECs, but in the product name definition, you say it's RECs sold under the same contract as an energy sale with a separate price. Or just in the bundled, if you go with a bundled like renewable product, that would be implied. That would be the energy and the RECs.
Okay, we don't have any questions coming in. I think we've discussed or covered the questions that are that have come in. A lot of them were the basic questions about why would we report RECs, or when do you report RECs when they're bundled, and Roxana helped clear that up. Thank you, Roxana. So if there's any other discussion on this, please. I think there was a gentleman who had his hand raised and I missed it before you lowered your hand, so I'm going to assume that your question was answered. But apologies if I missed it. But if there's anybody else who has anything that want to add, please raise your hand. Or if you've already been unmuted and you have control over your mute button, just jump right into the conversation and or put something in the Q&A.
Okay.
I think that's it. So Hala, if you want to continue on.
All right. So the ramping is another concept that is being put in other, but we'd like to understand better why filers are using this term in other. We'd like to jump right into the discussion on the following questions. What are your thoughts on staff proposed to add ramping as a new product name in Appendix A? And should other ramping related products be added to the Appendix A?
Obviously, same rules apply. If you have anything to say and have control of your mic, just jump in or raise your hand and I can unmute you. Or Q&A. Go ahead, Barbara.
I just have a question on ramping. The only time I've seen ramping is in an ISO, and actually specific, I think I've only seen it with the California ISO. Is there a time when anyone selling to someone other than an ISO would have ramping? Because I just think, oh dear God, not another one is my reaction. And I do appreciate the opportunity to discuss this. I think it's much better to have a technical conference and discuss these things, and rather than just get hit with a rulemaking and get into a whole issue. And I think that it's made difficult because of having to do it all virtually. But I do appreciate that you're asking for feedback and we're able to give it. So I don't want to be all negative, but sure. I just, you know, this circles back to my, if it's only ISO, can't we just get rid of the, didn't raise the issue of stopping the reporting of the ISO transaction. So that's my 2 cents.
That's the holy grail, Barbara.
Please.
We're gonna find it someday. I assure you. But
Hey Barbara, this is Jeff. Hey, thanks for that. And yeah, I mean that's a good question. I mean, out to everyone else, has have other people seen ramping non-ISO places, transactions, bilateral regions?
This is Renee, and I've not seen any with my companies, but we don't have anybody in Cal ISO yet either.
Okay, thanks.
Oh, hey, yeah, Penny just jumped on and jumped off. I guess that was it. Okay, Penny, I can unmute you. Go ahead, Penny.
Hey guys, I would just add, just my only interjection is if we can't get Barbara's request of eliminate ISO reporting, at least push CAISO to provide EQR transactions. I think that's a huge elephant out there with the inconsistencies in reporting because they don't provide transactions. So that's my comment.
Amen to that, sister.
And I do too appreciate these discussions. They're very enlightening, and I do appreciate all y'all's hard work and involving us in this. Thanks. I'm off.
Thanks, Penny. Just you can put yourself back on mute and lower your hand. If you have something else to add in the future, you can go ahead and do it.
There.
Oh, Sherry has her hand raised. Go ahead, Sherry.
Hi, this is just in relation to ramping. We file EQRs for the Southeastern market, well, which isn't really a market, but tolling agreements, bilateral deals. And I echo what Barb was saying, that adding something else would not be great. I know we report start fuel, start charges. I don't know if that's different or you consider that different, but it is reported in a tolling agreement as a product description and names under other. But so those are just my thoughts, and I want to echo what everyone else said, that I do appreciate this and being able to talk about it. But that's where I see quote ramping perhaps.
Okay. Yeah, in the next slide, actually, we are asking you if you see any other products that you think is useful to add to the list, and we can definitely consider that also. But Barbara, I have a question. You said you saw that ramping on California, Calayaso. Did
Yes.
you do you remember if is it just plain ramping or different flavor of ramping, or do you know it's just said ramping or ramp
What
up,
there
ramp
was,
down?
probably my guess, given that California, they can complicate anything. And so my guess is there's at least 2, if not 4 or 6 charges related to ramping. I can't off the top of my head tell you that, but I suspect there is ramp up and ramp down. And then God knows they figure out a way to create a bazillion new billing categories out of it. So I don't know for sure. I can try to look it up. I'm not, but it just, yeah, when I saw this about ramping, I thought, oh dear God, no. But
yeah, okay, sure.
I'll tell you that California ISO made a commitment to me when I was still at FERC, and it was 2003, that as soon as they ended what was then to become MRTU, which they thought was going to be in 6 months, but ended up being more like 6 years, that they were going to turn right to this EQR thing and create a formatted report. They were the first one we talked to. And so it is frustrating that they're the only ones that haven't done it.
All right, thanks.
Yeah, it seems like we've kind of sped through this. I thought the Rex would take a lot longer, just based on the interest in the questions. So Hila, your call. Do you want to jump to the next slide?
Yes. Yes, that is, these are our last question that we pose to you all today, and we like to hear from today's participant what is difficult for filers to report in Appendix A. And for filers reporting other and leaving the rate description blank, what products are you including in this field? And are there any other additional products that should be added to the product name list in Appendix A?
All right, don't everybody start at once. Hey, Barbara, go ahead, and you can unmute. Right.
Okay, yeah. I was waiting to see if someone else would jump in first, but one of the issues related to other, I know there have been times that I have like a complex PPA, and you go through it and you list all the products and all the prices and do that, and you start reporting it, and you go humming along for a couple of years, and then all of a sudden you see something on an invoice that is different from what you did. The contract hasn't been amended, and it's difficult to foresee that. I think you can go back maybe in retrospect, look at the contract thing and say somehow this language buried in this paragraph would indicate that yes, they will pass some sort of charge through. Frequently it's something from an ISO. And at that point, I'll just add other to the product categories and then report it in the transaction. So I've got everything that's on the invoice reported fully, but it's so concerned about the suggestion earlier in the meeting that anytime you changed anything, if you don't change the commencement date, that it was going to be an error and you wouldn't be able to file, because that stuff just happens. And sometimes there are changes that are made verbally that never really get codified in a contract, but they're being paid for. They agree to something, and so you have to make, you want to be sure that you're reporting your stuff completely. So that would be a problem. One suggestion I may have, even though it definition of other rate description, but maybe if you sort of said some, like a best practice might be to describe in the rate description field what the other category was. At least that could help inform your decision making as you're going forward and changing fields. If people started putting a little more data in there, then you'd get a better sense of what it was. And and then for the third question, and I've already mentioned this, I think about different from bundled with transmission. I think that whole discussion should be continued so that you get the best combination of things. What's most useful, what's most common. Like I said earlier, I bet there's at least a couple hundred contracts that would use renewable energy, bundled renewable energy, and that might cut down a lot on the others that you don't know. Well, of course, that would be the separate REC. There's also, if you had REC but qualified the way Jennifer mentioned, I think that's a lot of others too, because sometimes it's bundled and sometimes it's priced separately. And then sometimes, like in the case that I think it was Sherry was talking about, it's a completely different contract. And so it's not even FERC jurisdictional, so it doesn't need to be reported.
Okay. Thanks, Barbara.
I don't see any questions in the Q&A. No hands raised. Except for Lisa. Lisa, do you have something to say? I'm gonna unmute you just in case.
Yes, I just wanted to follow on, and I probably shouldn't say this to Barb, in changing fields. Sometimes you find just in the freeform fields a typo. So you would get an error message if you wanted to correct your small typo, because it would look like that field changed. And that's all I had to add.
Which field are you talking about?
Just say the rate description or any freeform field that maybe you saw a typo in that would trigger a new validation that said you changed a field, so you need to change your commencement date.
Yeah, I think you're agreeing with what I said earlier, Lisa, that there are times you go in. Yeah.
Yep. Like I'm just correcting a human being.
Okay. Sure.
Okay. Oh, there's Renee. Hey, Renee, I'm going to unmute you. Go ahead.
So can you clarify again, please, the difference between when a REC would be reported? Is it only when it's bundled with energy versus being sold outright by itself?
That's how I understand it. Roxana or Maria?
Hi, Renee. It's Maria. Yes, that's. I think that is an accurate understanding.
Okay, thank you.
Can I clarify? My understanding is it's not necessarily bundled in the rate, but it is in the same contract as the energy.
This is Jennifer. Maybe I could help. I can give.
Jump in, Jennifer. Go ahead.
Sorry, Barbara, Barbara keeps breaking up a little, so I never know when she stopped. I have two sites that might help. 168 FERC 61041 and 139 FERC 61061 are two of the better cases that explain when FERC has jurisdiction over RECs and when it doesn't.
Can you repeat those, Jennifer?
Yeah, 168 FERC 61041 and 139 FERC 61061. I think those are some of the best cases I found on describing REC jurisdiction.
Okay, thank you.
Okay, if y'all could make sure you're back on mute. And I think we may be at the end of today's technical conference. So, Hela, Maria, or Marina,
Yep.
I guess it's up to y'all. Yeah.
Yep. Yeah, we are going to take back what you shared today and prepare a summary matrix after the tech conference that will summarize our proposed changes. And our goal is to help provide an efficient way for filers to understand what parts of the EQR we cover through the tech conference process and what our proposed changes are. The next step is to stay tuned for announcement about the second tech conference coming up in late spring or early summer. And we'll have multiple tech conferences, as many as we needed to cover all the fields. We plan to use the same docket number for all the tech conference in this proceeding, which is the AD 218. And if anyone wishes to file formal comments, they can submit those under this docket at any time or after all the tech conferences conclude. You can also email eqr@ferc.gov if you have any questions. Please make sure to add the subject line EQR Tech Conference if you send your question to eqr@ferc.gov.
Hey, Sohaila, there were a
yes.
couple of questions that came in literally in the last minute that we were talking, and I think they may have just come in. So, Penny, I'm going to make your question, and we're going to answer it verbally. But I'm also going to unmute you if I can't find you anymore. But I'll read your thing, Penny Featherston. Is energy curtailments by purchaser where seller is asked to not generated yet paid for as if they did? Should they be reported? And if so, do we need a new product name? Penny, I'm going to try to find you in the participants list, but you probably have control over your mute and unmute if you want to unmute and make sure I got that right. There you go. You're set. Go ahead and talk, Penny.
I did? Okay.
Yeah.
Well, I'm just seeing out in the West with the renewables where we have contracts that provide for the off-taker to direct the unit not to generate at capacity. And for that, there's a calculation done where we are paid as if we did deliver the energy at the contract price. And is anybody else seeing that out there in their contracts?
Yes, there's a lot of them.
Okay, and I just wanted to confirm that it's just one of the issues that if that it's not really delivered energy, I don't know if, should that be reported, and if so, under what product name? Do we need a new product name?
Because I think it goes into the price of the energy. I mean, it affects or is affected by this the same way that RECs, if they're included in a jurisdictional contract, FERC has decided are reportable, then that curtailed energy, if paid for, are reported as other.
Okay, and that's the way I've been reporting it. That's why I'm asking that if everybody does agree that it needs to be reported, that may be a lot of that other you're seeing, and I do put in a price and a volume on it. It's also very difficult because it's invoiced so late. Trying to come up with that calculation, that's kind of a problem we have. So I have to hold off on a lot of the filings, trying to get that last month invoice to see if we have it yet. But just then throw it out there. Do we need a new product name for that, or should it just be left as other?
Yes, Penny, thank you for reminding us that of that. Yeah, so curtailment is reported, and I've been asking market participants to put curtailment in the rate description. However, when I go and look at the data, I'm not seeing a lot. That doesn't mean it's not happening a lot, but it could be that it's not marked as curtailment, or market participants simply might not report it. But that's a really good product name that could be added to Appendix A to emphasize the fact that there is curtailment in that power. So there's something that I'm just finding out right now. So you're telling me that you know the price of that curtailment at a later time? How late do you actually know the price that you're getting paid for that curtailed energy in the process versus, when you actually deliver the power?
I'm sorry, am I still on? Can you hear me?
Yeah.
Yes.
Okay. And well, actually, it's the contract, right? It's the rate that I know. It's the volumes that take a while to come up with because somebody's got to calculate the what if that unit generated, and then they kind of agree with them with the off taker. Yeah, and it's just, and yeah, and there can be minor, adjustments to them. It's just, yeah, it's usually not much money, but it's a lot of work.
Yeah, this is Jennifer, and I just wanted to comment on this conversation. I might actually disagree with Barb on this. I would think a product curtailment or, not generating and being paid, I can't see a difference between that and the demand response product, which is absolutely not FERC jurisdictional. I mean, if you're not selling energy, that's what FERC has jurisdiction over. And, there's a reason demand response is not, listed as a product, and there's case law on it. And I think that's something, that's a jurisdictional call as to whether it's a product that's possibly reportable. Because, just the fact that it's in a contract, there's lots of contracts with demand response in them, but that doesn't make them, it doesn't make them jurisdictional as to the demand response. Because then you could say, charging a storage device is all of a sudden, that somehow in some regions, including CAISO, likes to call that net negative generation. Well, that's, when you're charging a storage device, you're buying energy. That's not a jurisdictional sale, even if the CAISO likes to call it your, net negative energy. That's just, it's just not jurisdictional. So, I think we need to tread lightly, and, there might be some pushback, and, bring it up with the legal staff as to whether the service of not providing energy is a reportable service that's jurisdictional. Might be in a jurisdictional contract, but it doesn't mean you have jurisdiction over it.
Thank you.
So, and I'm not trying to be critical on everything Barbara said about not being critical, but I think there's legal issues here that, that go into jurisdiction, and I don't think those of us who are lawyers on the phone want to see jurisdiction expanded over products that we don't think are jurisdictional.
Well, then what do you think about the RECs? Because RECs by themselves are not FERC jurisdictional. And so using the rationale of you include, that's how I inferred that, the curtailed.
I can't, yeah.
You what?
I'm not sure I agree with FERC on the REC things.
Okay.
I think the curtailment is so close to demand response, and it is a form of demand response. There's too much power, and they're telling you not to generate, and that is demand response. The same thing if you're given an order to charge a battery. I don't think that's a FERC jurisdictional service you're providing. It's, the product isn't, it may all be controlled by a FERC jurisdictional contract, but it doesn't mean the product itself, just as the demand response market is wholly controlled by, an ISO tariff, we still, demand response does not appear on this list.
But, well, and I would be fearfully curious to hear the staff's position on demand response. Never followed up, but because I don't think it's explicitly stated in any orders, but there are people that are selling demand response into PJM, I think.
Right. Well, it's just explicitly stated that it's not a FERC jurisdictional product. It's not. I think it may be stated somewhere that it's not covered by EQR, but I think the fact that it's stated in orders that it's not a FERC. If you sell nothing but demand response, you're not a public utility, so you have no EQR responsibility anyway. And there are cases that say the product isn't jurisdictional when sold to an ISO market.
Good
Hey,
answer.
Jennifer, there's been a couple of people that have asked for those citations
yeah.
again. Could you without us,
Want me to
could you
put
just
them in the
repeat them or put them in the chat?
yeah.
Either one. Yeah, that would be lovely.
Okay.
Oh, yeah.
Okay, Rob, is there any other questions that we didn't answer?
No, I don't have any questions, but I'm going to let's wait until Jennifer can get them in the chat, because once we end this, it'll end and no one will be able to copy them down.
Sure.
So as soon as she drops them in somewhere, we'll give people a minute or two to copy and paste into a notepad or something like that.
Okay, hold it. I think.
While Jennifer is doing it, is there any last thoughts or comments?
Yeah, I know Barbara wants us to talk about demand response, but we'll save that for another day. But if there's anything else here, or is there anything? Is there anything that, if anyone has any comments about fields that we should program to talk about in the future, we have our list. We'd love to hear about your list of things too, or just please email us at eqr@ferc.gov. But I know that there's a long list of several more tech conferences that we have planned to continue doing just this.
Yeah, and we will cover all the fields. We have multiple tech conferences, as you said, yes.
Okay, so Jennifer sent them to me. I will put them in the chat for everybody. So we have not reviewed these. The EQR staff hasn't actually had a chance to read these in real time, but this is copied and paste what Jennifer Key mentioned. So there you go. And I think that's it. So as soon as most people start dropping off of this line, oh, there we go. Will the conference cover files received from the ISO? Hi, Sherry. No, so Sherry asked a question. Will any of these conference cover files received from the ISOs? No, we don't have access to your EQR tool to understand the files that come from the ISO. If you're having problems with the EQR files that your ISO is creating, we can bring that up with them in some of our meetings that we have under an alignment project that's separate, but we wouldn't be talking about the files that they create in this forum. That's something you have to bring up with the RTOs and ISOs individually, or in their however they're organized, and you can provide comments on items for them to bring up for discussion. And I think that's it. If no one else has anything more, we'll wait a couple of minutes for the attendee list to start dropping off a little bit more before we close down, but feel free to sign off. And thanks everybody for participating. Thanks Sohaila, Marina, Jeff, Roxana, Maria, Dawn, everybody else who added to this discussion, Barbara and Jennifer, and I'm going to forget everybody, so I'm not going to try. Renee, and Penny, and everybody who participated. We hope that this was helpful, and we think this is a great way to do this when we can't congregate together. This is kind of the style that we'll do for the next one if we still can't get together then. So any comments on how this worked, please send that too. So thanks everybody.
Thank you.
Thank you.
Thanks.
Thanks, Rob. Thanks, EQR team. Appreciate the work on this.
Thank you.